Yes.
And we could find CRAN 9.
CRAN 9.
Our joint application, and can we see the allegation? It was not grabbing of property, assault in public, nothing. Just utterance of one expression.
Yes.
Which brought us in the purview of this act.
Yes.
Look, in this CRAN, we have the complainant, Emmanuel Ekka. He has complained through his son, but the complainant himself has come and he has deposed and supplementary affidavit as per the desire of the direction of the court. We have done that. That is what I'm saying. That is exactly what I'm saying. That has been served also. And my lord, we have 5 case laws. Then my lord, the difficulty becomes that those case laws go to prove that the complaints were false. Here it's completely different. We have agreed to say there are 2 different things, my lord, altogether. That is why I'm repeatedly.
Case would be whether it would be an abuse of process. And while I think Leonard friend, senior friend is agreeable on this, the continuation of this would be an absolute abuse of process.
Lord, I am not again, my lord, going into the abuse of process, those expressions. I am only beseeching your lordship, my lord, that because we have agreed and that they have redeemed our dignity by filing this, may be disposed of in the light of the memorandum of settlement. Expressions complicate things, my lord. These are judicial expressions. They mean a lot. They have deeper meaning. I don't want to go into that. Is my respectful submission.
Its judgment is not applicable.
That is what that means.
So appearing for the petitioner, so appearing for the state, and so appearing for the de facto complainant. Full stop. The petitioner has filed the present application being CRR number
9 months. CRR 158 of 2024.
CRAN.
Are there 157 দুটো আছে না 157 disposed
Lying, bro. Where is CRR? CRR 158 of 2024. Praying for quashing of the proceeding in connection with FIR number 200 of 2024, dated 20th April 2024, of PS Malbazar Police Station, of Malbazar Police Station, under section 3 within bracket 1, 3 within bracket 1, 3 within bracket 1 within bracket small p, within bracket small q, within bracket small r, and it's within bracket s of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Police. Counsel for the petition submits that on the basis of the written complaint, on the basis of the written complaint, of the complainant, namely Emmanuel Ekka, the police of PS Malbazar registered the above case. He submits that as per the complaint made by the complainant and de facto complainant, it is found that in the normal course of business as per the guidelines of the Indian Oil Corporation, the gas field cylinders from the place of the business of the de facto complainant, along with the delivery challan, and after appropriate entries are made in the described register, the delivery persons carry them to the consumers and cause due to delivery of the gas filled cylinders. Now, submit that during the normal course of business, the field officer, is the accused is the field officer. Accused was the field
No,
officer.
field officer.
The field officer, the accused who was the field officer. Field officer has surprise inventory inspections after causing physical inspection at the place of business of the distributors and on 11th January 2024, he has prepared the latest surprise inventory inspection on 12th of January 2024.
Milord, he is the senior manager LPG station.
LPG.
Senior
not
manager.
field officer.
Oh, that is the main thing.
He is a senior manager.
Senior manager.
Then it is a-
Senior manager.
LPG sales, senior manager, LPG sales. That is Anurag Tiwari.
Anurag Tiwari.
Anurag Tiwari.
Can I hand over the file?
That's it. This is the copy of the company.
क्या बोला ऊपर से जब पैराग्राफ शुरू किया हाँ डिफेक्टिव कंप्लेंट बाकी काट दो डिफेक्टिव कंप्लेनेंट the accused during the course of the inspection did not stop himself and merely refusing to disclose his credentially out of his way and reason for carrying out the aforesaid unauthorized inspection, but when the complainant has inquired about his sudden visit, comma, the accused has committed the alleged offense. Police. Counsel for the petitioner submit that after the initiation of the proceeding, comma, the petitioner has filed the present application for quashing of the proceeding initiated against the petitioner. During the pendency of the proceeding, comma, the petitioner and the de facto complainant have settled their dispute and entered into a settlement agreement. After the entering into a settlement, comma, both have filed a joint application in the present proceeding, being CRAN number 9 of 2025, by disclosing the memorandum of understanding entered between both the parties on 28th of February 2025, wherein it is mentioned that both the parties have settled their dispute outside of the court, and the de facto complainant, being the first party of the agreement, unconditionally withdraw the criminal complaint and all related proceeding initiated against the petitioner herein.
And also a supplementary affidavit to that effect has been
Police.
filed, which
Police.
is dated, my lord, which is dated
Full stop. In the,
30th of April 2025.
which one?
Supplementary affidavit because in support of that CRAN 9, we have filed a supplementary affidavit also, which has been signed by the complainant himself. As per the direction,
CRAN 10. रुको ना.
No, Milord, it's just a affidavit.
it's just an
तो
affidavit.
देता वही
supplementary.
पकड़ा देता.
Just to keep the record straight.
Affidavit of de facto complainant.
Yes.
Minor, 30th of April. 2025. As per the desire of the court, Miller, because court wanted.
The de facto complainant has also filed a separate affidavit on 30th April 2025, affirmed before the commissioner, both commissioner of this court, wherein the de facto complainant stated that
Para
de facto
40.
complainant stated that he has no grievance whatsoever against the petitioner, that is the accused, before against the petitioner, and he do not want to pursue the proceeding against him for further. Full stop. The applications, the joint application filed by the de facto complainant and the accused and the petitioner herein also contains the affidavit affirmed before the oath commissioner of this court on 20th February 2025, wherein in the said affidavit also the de facto complainant has stated that in view of the settlement arrived between the parties, no further desire to continue with the prosecution of the proceedings initiated at the behest of the de facto complainant, being special case number 4 of 2024 pending before the additional district and session judge, first court, Jalpaiguri. Full stop. Considering full stop. Learned counsel for the petitioner has relied upon the judgment in the case of Ram Avatar versus State of Madhya Pradesh, reported in 2021 SEC online, SC 966, wherein the Honorable Supreme Court has held that mere the fact that the offense is covered under the special statute would not refrain the court or the High Court from exercising their respective powers under Article 142 of the Constitution of India or Section 482 of the Code of Civil Procedure. The counsel for the petitioner also relied upon an unreported judgment passed by the coordinate bench of this court in CRR number 1198 of 2022, dated 13th May 2024, wherein in the similar circumstances of the case, the coordinate bench of this court has set aside and quashed the proceeding initiated under the provisions of under section 31R 31 within bracket R within bracket S within bracket W within bracket I of the SC and ST Prevention of Atrocities Act 1989. Full stop. Heard the learned counsel for the respective parties, peruse the application, peruse the application, affidavits, and the materials on report. This court find that as per the allegation made in the complaint, by the de facto complaint, the petitioner has alleged to have been abused the de facto complainant, and de facto complainant being the member of the scheduled tribe has made the complaint, and on the basis of this complaint, the FIR has been chalked out. The petitioner has filed the present application on the ground that no case has been made out for the offense under the SC and ST Act, and only on the basis of a verbal discussion during the inquiry, the false complaint has been lodged. But now the situation has been changed. During the pendency of the case, the petitioner and the de facto complainant have entered into a compromise. It is the case of both the parties that this is the civil dispute between the parties, as the de facto complainant is running his business with the Indian Oil Corporation for the last 30 years, and the de facto complainant is intent to continue with his business without any hesitation with the Indian Oil Corporation. And during the pendency of this case, they have entered into settlement and is not interested to proceed with the case against the employee of the Indian Oil Corporation. Full stop. In the agreement, it is categorically stated that the de facto complainant unconditionally has agreed to settle the dispute between the petitioner, and he has no objection if the case and he will not proceed with the matter further. Considering the above, this court finds that if at all this court will not invoke the provisions of section 482 of the Code of Criminal Procedure, and it is sent to the learned trial court, again it will defeat the justice for speedy trial. If this court find that as per the settlement entered between the parties, no purpose should be served to send the matter to the trial, only for the purpose of examining the witness. Accordingly, taking into consideration, this court find that as per the settlement entered between the parties, though the case is under the special statute, but the procedure for leading the evidence is led through the Evidence Act. If at all if the case is sent to the trial court, again no purpose should be served, then the result would be zero. Full stop. Accordingly, this court find that to save the save the court time, and taking into consideration of the settlement arrived between the parties. This is the fit case wherein the proceeding initiated by the police on the complaint made by the de facto complainant, wherein the now the de facto complainant has entered into a settlement. The proceeding is liable to be quashed. In view of the above, just a minute. In view of the above, the proceeding initiated by the police of PS Malbazar Police Station, Police Station Malbazar, being FIR number 200 of 2024, 2024 under section 3 within bracket 1 PQRS of the Scheduled Caste and Scheduled Tribe Prevention of Corruption Act, corresponding to what is the special case number?
That is number.
Corresponding to
20.
corresponding to
Four of 2024.
special case number 4 of 2024
24.
pending before the
Court of Learned Additional District and Sessions Judge, First Court, Jalpaiguri.
Jalpaiguri is set aside and quashed. The petitioner has been discharged from all bail bonds if not required in any other proceedings.
Extremely.
If your lordship, if it comments to your lordship, that if your lordship kindly uses the expression disposed of instead of. And your lordship has also stated that I filed a false complaint, but I did not file any false.
No, allegation.
Well,
Allegation, I am not
No,
disputing.
but-
It is allegation of the petitioner false,
it is my fault.
made a false.
One
complaint.
line for the state.
Huh?
One line for the state, my lord.
ऊपर ना इस जगह लिख देना counsel for the state submit that this is the special statute and this court on the basis of the compromise entered between the parties cannot cause the proceeding.
Okay.
But if it is not caused, not caused the
Disposal, I don't think.
mere disposal, if it is not caused, then the district judiciary, the trial court will be in the difficulty. What would be the file of the
Outcome of the.
file of the proceeding?
Grateful, extremely grateful.
My learned junior is requesting that the victim has been represented if your lordship kindly makes one
No,
line.
you have recorded.
It is the, it's not.
So and so is appearing for the de facto complainant.
No, victim. De facto complainant is my father.
De facto complainant and victim.
And I'm deep.
That's I thought it is disposed of, but it disposed of, then what would happen to the process charge sheet and the FIR?
And without what they cannot, they can. I'm
Tomorrow, if we want to go to the foreign, then he will not get the passport due to the FIR.
true, very true. I'm deep.
If I hear you copy to them.
Yes, next.
My lord, item number 16, and my lord, I am being led by Mr. Sudipto Majumdar. my lord.
Yes.
My lord, he is not available this week, my lord, if it could be taken up.
Huh?
I am being led by Mr. Sudipto Majumdar.
What is the matter?
My lord, actually. he has
Lordship,
given
quashing.
me his-
Quashing.
Washing off?
Kindly takes it.
I
up.
am vacating this order.
My lord, there is. My lord, kindly gives me.
I am vacating the stay order and I am sending it to the month of June and I will direct the trial court to proceed with the
My
matter.
lord, kindly, my lord, it's.
Because
my-
the
my-
file is full of crime. Once you got the stay order, again and again you are extending the time, you are not coming to the court.
my lord,
Tell, I am giving option to you. If you want adjournment, I will give adjournment. I will vacate the stay order. I will not extend the stay order and I will direct the trial court to continue the
My lord gives me Passover, my lord. 10 minutes Passover, my lord, I'll take it.
password. 12:40 में matter देना.
70. Case for quashing, I want to file a supplementary affidavit at annexing the 161 copies.
For what?
Quashing of the
Boxo case quashing.
quashing.
For what?
But actually, at the relevant time, she was more than 18.
So you take the benefit in the trial court. See, you are the trial person. You are the appearing in the criminal matters. Correct. Whatever the police has taken the document that is on the charge sheet. If you want to rely on the document under the 482, the court cannot, in the revisional jurisdiction, court cannot go into the other documents other than the documents seized by the police, relied by the prosecution. Correct. If you want to rely upon certain document, that has to be placed during the trial only. This court either not in the 227 nor in the
Actually,
482.
my lord, this may case, if I assume, it may come under the purview of 354.
Maybe. So that you argue at the time of charge.
My lord,
The court, how this court, what is the stage of the trial?
charge yet to be pressed.
Then you file an application. Instead of this 354, it will go to the magistrate.
So they, and then seek some instruction.
No, this is just
Sir,
dilatory treatise. and-
nothing. I have gone through. You want to rely upon some document, I will give, I'm dismissing it, but you are liberty to whatever the document
ma'am.
at the time of trial, nothing else.
Right, my lord.
Correct.
Actually, I have been instructed to file a quashing petition because if that has been turned down, then that will go against me in the trial, on a trial.
No, that
That's why I am
Observation.
not observing anything.
no observation.
I am dismissing it. What you want? Correct.
They are permitted to withdraw the same.
Why
We
withdraw,
don't,
my
that
lord?
is the-
My lord, we have objection regarding.
Why?
it. We have called the CD, my lord.
Withdraw.
My lord, we have, my lord, after,
I am recording your objection.
but thing is that if this is encouraged, my lord, will be in difficult.
Withdraw.
Withdraw, my lord was in our position, my lord knows withdraw, what is the, so my lord knows better than us. So my lord, why withdraw, my lord? I am ready, my lord, I am holding the CD, my lord.
That's
This is not the first,
That's why.
no, on the first day, they would have said withdraw, okay, fine. After so many days, after again prepared, after doing the homework and everything, if they come and say withdraw, and we APPs cannot raise the withdraw bills also. We cannot raise the 50% bills, we just waive that. That is true, yeah, we are here to, we are working for money.
So and so offering for the petition, so and so offering for the state. Petition has filed the present application. Present application under section 438 of the BNSS. 438 read with section 442 of read with section 442 and read with section 4. Why you are telling that? It is subconduct. The petitioner has filed the present application. Present application challenging the order passed by the learned special judge, a special court, passed by the learned special judge Kalimpong, by order number 25 July 2024, 2024, in special case number 55 of 2023, wherein the application filed by the petitioner under section 227 of the CRPC was dismissed. Full stop. At the learned counsel for the petitioner and the state, this court find that the learned special judge Foxo court have considered all the aspects, and this court has considered all the points raised by the petitioner in the said application. Full stop. This court find that if the petitioner has taken the point with regard to the age of the victim, the petitioner is liberty to prove the age of the victim during the trial. Police. Considering the above, this court did not find any illegality in the order passed by the learned judge in special court Foxo Kalimpong, dated 25th of July 2024. Accordingly, CRR 302/2024 is dismissed.
Well,
Yeah,
thing is that on many, I have to approach before the learned trial. But if that-
Yeah,
For what? For what?
On merit,
Already given the liberty to you place all the document before the trial court at the time of trial, because your 227 is rejected. So now trial is there. Trial you can agitate all the things. Next.
I am for the state.
Yes.
For the petitioner, my lord. Lord, On the earlier occasion, my lord, there was a direction to file a report. my lord.
Yes, report.
Lordship, till today, no report, the concern IO is at Bangalore for medical treatment.
The IU has gone well after, if the investigating officer or concerned police officer or the concerned police station is leaving the station, he is not handing over the case diary to the other police officer. It has not been assigned to the other police officer.
Lordship, case diary is here. Case diary
No.
is here.
So if the case diary, there's a report is to be submitted. Your officer in charge is not in the police station.
Officer is obviously.
why-
the police station.
Why the report has not come?
Lordship, let it fixed on Monday.
Call for the report by investigating officer of only about the truthfulness of the alleged sale by the petition in favor of the principal accused in the year
Yes,
2017.
because they are relying only on the on a deed for agreement of sale, but no RTO registration. No RTO registration. The Lordship knows far better than me that mere relying on this agreement will not serve the purpose, because RTO registration is required for the change of ownership.
No, but the problem is, see, that is with regard to the change of ownership.
Or
If the person is sold the vehicle to the second person, then it is a duty of the owner to intimate the registering authority within 15 days.
this is the law.
That is the law.
Well, that is the law.
Correct.
Yes.
But here with regard to the, this is not the case with regard to the registration. Now you have entangled this person because the vehicle is registered in his name.
Yes.
Correct.
Yes.
And that's why you have entangled him.
Yeah.
Now he has taken the plea. So though the vehicle is registered in his name, but in the 2017 itself, he has entered into a sale agreement. Prior 2016, it has been given. Subsequently, 2017, he has entered into an agreement. It is the duty of that person, but he has not taken any step. So whether on that day has any liability of this person, he has used the vehicle. So what is the criminal liability?
Lordship, Lordship won't get annoyed, I think. In their petition, in their petition for quashing, they have not transfer of ownership, the form 29. Form 29, which they have annexed at page 14. That what is the fate of that petition? That is not clear. So for that reason, the report is also required.
Yes. 20, that's a form 2930.
Yes.
Form 2930 is with regard to the change of ownership.
Ownership.
Correct, as per the Central Motor Vehicle Rules.
Central Vehicle.
Central
This is
Motor
the law.
Vehicle Rule,
Central law.
2930 plus the what we said, revenue receipts.
Revenue receipts.
Revenue receipts and the address proof. These are the documents. No, here, please you consider it. Please you consider
No.
what is the criminal liability of this person?
Actually, Lordship have correctly observed that on the date of the committing the offence, whether this person who has been arraigned as an accused in this case was having any onus regarding that vehicle or not. This is the point. Lordship, Monday, let the report come, so we'll have a final hearing. Much obliged.
So suffering for the petitioner, so suffering for the state. As per the submission, as per the prayer made by the counsel for the state, the case is set on. Let the matter appear on Friday.
Monday.
Then 20. 20. Tuesday.
Tuesday. Much obliged.
Item number 72. 72, my lord, I have the petition.
Yes.
So, my lord, out of a suo motu complaint, my lord, I have been arraigned, my lord, along with others. My lord, an
lord,
allegation of the West Bengal Gambling Act. My lord, my name, my involvement has been dragged, my lord, with regard to, my lord, the confessional statement of the my lord, arrested person. My lord.
My lord, I pray for
Nothing has been
accommodation, my lord. I am not able to trace my brief. And
Gambling.
no, there is arms act. There is an allegation of
Arms act not from him.
My lord,
Only you check it with regard to the arms, what is the connection?
I will call for
That
the
if it is not connection with the arms gambling act,
My-
what is the board amount?
I think 4,000 something.
He's enjoying a stay, I think.
No,
No stay.
4,900.
4,900 gambling board.
Monday, my lord. I'll call for this.
Tuesday, 20. As per the prayer, no,
Yes.
like 20, 20.
20.
Yes, next.
73.
Lord, I am for the petitioner.
Yes.
Lord, in the year 2000.
Lord, I'm for the opposite party.
In the year 2009, Lord, marriage was solemnized between the petitioner and the OP.
Ah,
Lord, 2012, Lord, she voluntarily withdraw the companionship of the husband and she goes to her paternal home. Lord, 2012 itself, maintenance case was filed, 120 at CRPC, 4,000 maintenance was granted. I was paying diligently, Lord, from time to time. 2021, Lord, he preferred 127 application for enhancement of the amount of compensation. Lord, in that application, Lord, the learned trial court has considered my income, my enhancement in income, and Lord, made the maintenance amount from 4,000 to 10,000. Lord, though she has paid for 8,000 rupees. So Lord, I am enjoying an interim stay that I shall be paying 8,000 rupees till the disposal of the instant revisional application, and I am doing that. I am paying 8,000. Lord, my only humble submission before your lordship is, Lord, let that order be made absolute. Lord, I am paying 8,000. I will be continuing.
what is the order of the trial court?
Order of trial court is.
What is the amount total?
Lord, perhaps the certified copy.
Judicial Magistrate Alipurdwar. That is the order.
Yes, Lord. Third Judicial Magistrate Alipurdwar.
Alipurdwar, dated
Yes.
11 July 2022.
He-
4,000 order maintenance, 4,000 per month. In connection with miscuse number hereby enhanced to 10,000.
Yes.
Yes. So, my Lord, I am praying, Lord, let it be 8,000. I am paying 8,000.
So what the appellate court has, have you filed the appeal?
Yes.
Yes.
A revision
Yes, ma'am.
or appeal? Revision.
Revision.
What the revision court has upheld the order?
My last page of the brief,
Correct.
last two.
It has upheld the order.
Stand,
Upheld the order.
upheld the order. Correct. What you are doing
Lord, I am a constable in the West Bengal Police.
and what did the lady do?
My Lord, lady is, Lord, she is not.
Any child?
No child.
No child.
No child. My Lord, 33,000, my Lord, I am getting in hand salary. My Lord, I am paying 8,000 rupees. I have loan. And my Lord, I have dependent parents as well. My Lord, 25,000, my Lord, I am paying in loan. And so, my Lord, if 8,000, my Lord, is paid, my Lord, well, if 8,000 is granted, my Lord, that will be bit convenient for me, my Lord, to carry it forward. But that's my only humble submission. But even last month also, every month, Lord, I am paying time to time. Lord, 21st of April is the last date of payment. Lord, I have made 8,000 rupees.
Yes, how there is. Finally comes to the order of the London Magistrate, page number 4, third paragraph. Yes, category has taken into consideration all the things.
Yes, my lord. Lord, I have certain points to be raised if my lord permits.
Yes, my Lord, those points were considered.
Hmm.
My Lord, they have taken into consideration, but my Lord, the reasons.
You are
that's
having
of-
40,000 rupees.
My Lord, that is my net pay.
Correct.
That is my net pay, but my in-hand salary, my Lord, is approx 34,000.
34,000 in
Yes.
hand. And you have taken the loan,
Yes.
study loan. But why you have taken the personal loan? Why you have not taken the study loan?
My Lord,
for your-
because bank was not, my Lord,
And you are-
inclined to give personal,
You are-
educational loan.
Your another brother is also working in the
Working
BSF.
in BSF,
Yes,
is
ma'am.
staying separately with his family.
Maybe.
But I am taking care of my parents.
No, my
Maybe.
lord, over my instruction.
Just, yes. Yes.
So, my lord, that is my only humble submission, my lord. 10,000 the learned court has granted. My lord, she has prayed for 8,000 from 4 to 8. My lord,
Where,
just see the
where is,
order.
where are application? 127 application have you disclosed, enclosed, not?
Yes,
You're not enclosed.
in the application, my lord,
Where is the 127 application?
what
What,
in the order the learned magistrate has
where is,
observed that.
where is it?
My lord, internal page of the internal page 2, first paragraph.
According to petition by filing the instant application, paid for enhancement of maintenance allowance from 4,000 to 8,000. Then,
But my lord, kindly see his net pay. last-
maybe, but you have paid for enhancement to 4,000 to 8,000. And
But my
magistrate
learned
has
court
given.
allowed 10,000 as
Then-
because his income is now, my lord, 46,000.
So if your requirement is 8,000, how the magistrate can go beyond that?
My lord, it is the petition in the year of 2021, I think. But my lord, the order has been passed in the year of 2024.
Hmm.
In that year, my lord, 2000 must be raised.
Have she adduced the evidence? In the
Yes.
127 application, evidence
Yes, my
was
lord, I have
adduced.
said 39,000 is my net pay.
No, so what is the evidence? What is your prayer in the evidence?
In my
127 filed, the 127 is decided after the evidence only.
Yes.
Correct.
Yes.
In the evidence, the petitioner might have been given the evidence.
This
What is the,
evidence they have given?
so what
39.
is the evidence in the, before the land trial, before the land magistrate? If you prayed for 800, how, 8,000, how the 10,000?
My lord, I have to take some instruction regarding.
What instruction?
But kindly consider that I am diligently following the order of this honorable court, my lord. I am paying 8,000. Let that order be made as well.
No, my lord. My lord, the petitioner suppressed the fact that, my lord, he has
That's
been.
correct. I am not going to
me,
anything.
Malad,
Only the court is of the
Yes,
view.
ma'am.
Once you have prayed for the 8,000.
Let me, my lord. The petitioner is married to another, and there is a child. My lord.
Kind of a submission is there.
you are
Let it
mentioned
submit,
in
let
their
it submit,
application.
yes.
Thereafter, my lord, the petitioner taking the point that he has a loan. My lord, kindly see the.
I have gone through.
My lord, he filed the
He has
Vokalatnama
not
and
given,
thereafter,
he
my
has
lord,
not
he
given
taken
the
the
correct
loan.
affidavit of assets. He has 40,000 rupees, 34,000, then he has taken the personal loan and he has made a false statement suppressing the fact that brother is working in the
Yes,
BSF.
ma'am.
I have gone through, sir. Need not to. Only that's why only one question here now the point of law, because there's a revisional application, the court has to see the illegality of the order.
My lord.
With regard to the facts, the court cannot go into that. Only with regard to now, he has pointed out you have prayed for the 8,000, the magistrate has granted 10,000, whether it is permissible or not.
My lord, because the petitioner has been made the application in the year of 2021.
So-
And in the order has
But
been
at
passed
that
in the
time-
year of 2024. My lord, at that time, in the 3 years, in between 3 years, the inflation may be high.
Sir,
My lord,
filing
I
an
have
application-
understand the point.
If you're filing an application today
My
for
lord.
maintenance,
My lord,
correct? You are keeping the 5 years
my lord.
before, then you, suppose you are filing an application, what? You will pay for the 40,000 rupees?
Yes, my lord.
So you on that day, 2021, you filed an application for 8,000. Might the court proceedings go like that? But the court cannot say, no, he has paid for the 8,000 rupees. Now 2024, you are entitled to a 10,000 rupees. Because on that day, what you filed an application, what is the change circumstances on that day? Not the during the pendency of the application.
My lord, I will.
127 is to be filed, change of
Yes, ma'am.
circumstances.
Yes, my
For
lord.
enhancement or decrease or variation, whatever it may be.
My lord.
So that is the change of circumstances on that day when you filed an application.
My lord, let it be tomorrow, day after tomorrow, I will educate myself and come back, my lord.
Ask your client,
My lord.
you have prayed for 8,000.
Yes, my lord.
What is our contention?
No.
And he is paying the 8,000. See. When? Tomorrow?
Day after tomorrow.
Friday.
Day after.
Friday.
Extremely.
Friday.
Let the third order be.
So and so applying for the petitioner, so and so applying for the opposite party. The petitioner has filed the present application challenging the order passed by the London magistrate, which was affirmed by the London session judge, affirming the enhancement of the maintenance order from 4,000 to 10,000. Full stop. Counsel for the petitioner draw the attention of this court that the petitioner, that the opposite party wife has filed an application under section 127 of the CRPC for enhancement of the maintenance amount from 4,000 to 8,000, but the learned magistrate has granted, has allowed the enhancement from 4,000 to 10,000. Full stop. Counsel for the opposite party opposite party prays for time to take instruction. According case adjourned and the matter appear on 16th.
What you get from it?
Next, item number 40. पासवर्ड कौन बोला? पासवर्ड कहाँ से आया? 69 पासवर्ड किया, 69 पासवर्ड हुआ. Who is for the petitioner? Please to extend the interim order.
Ravi Prashad.
Cran, CRR. On the opposite party, MP proceeding. What is the offense?
Lordship, the offense is
406, 420.
Lordship.
Acha, resignation from the board.
He has resigned earlier.
Resignation.
Yeah, I cannot say because is the petitioner's first page.
Who is the petitioner?
Because the daily registrars.
Correct.
It is, but it has to be.
My lord, am I audible, my lord?
Yes.
My lord, I beg to be excused for appearing virtually because I had to come out to defend Union of India and before the Honorable Chief Justice Division Bench in Sikkim High Court.
Okay, no
If
problem,
my
no
lord-
problem, no problem.
My lord, kindly accommodates me on the Friday, I will do the matter.
Okay,
Grateful, lords.
Friday. Next.
My lord, if I am permitted to indicate, my lord.
Yes.
My lord, we have another matter, union matter in item number 83, my lord.
Okay.
So, my lord, instead of wasting your lordship's valuable time and waiting up to it, making your lordship go up to 83, my lord kindly assigns this on Friday. I will be indebted, my lord.
83 also Friday.
Grateful, Lordship.
They're extremely obliged, my lord.
Yes, call the matter.
Item number 74.
Put the petition line of matter.
Yes.
Madam, my lord, I prayed for quashing of a proceeding which has been initiated against me under section 498A and 494. My lord, kindly comes to the FIR, my lord. That is at page number 13 onwards, my lord. 13 onwards. Now, my lord, what is my locus, who I am, and what does the law say about this offenses being attracted against me? My lord, may I summarize? My lord, I happens to be an individual woman against whom at the last paragraph of the FIR, an allegation has been made that I have maybe I had an affair with the person who is primarily accused of 498A here. My lord, I beseech your lordship to take up section 195 for 1. Your lordship knows it better than me, but for my satisfaction, my lord, I'm only submitting.
Yes.
But in 498A cases, only the relatives of the persons and the husband, they can be implicated. Against me, my lord, in this case, a charge sheet has been submitted under section 498A of the IPC. Now, my lord, kindly comes to section 494, which, according to the prosecution, happens to be their case against me.
494 of IPC, my lord.
Yes.
My lord, it says marrying during lifetime of husband or wife. Whoever having a husband or wife living marries in any case in which such marriage is void by reasons of its taking place during the life of such husband or wife shall be punished with imprisonment of either description for a term which may extend to 7 years and also be liable to be fined. Explanation: the section does not extend to any person whose marriage with such husband or wife has been declared void by the court of a competent jurisdiction. And second parameter, not to any person who contracts a marriage during the life of a former husband or wife, if such husband or wife at the time of the subsequent marriage shall have been continually abstained from such person or the space of 7 years and shall not have been heard by persons by persons as being alive within the time provided within the person contracting such subsequent marriage shall before such marriage takes place inform the person with whom such marriage is contracted or the state or the real state or the facts of the so far as the same are within his or her knowledge. Hence, my lord, my locus in this matter, my lord, only
Who are
an
you?
allegation.
Who are you?
Yes, my lord. That is the question I asked myself, my lord. My name has been implicated in this FIR, saying that I had fled away with the person who is primarily accused of 498A to Bhopal. I have never been to Bhopal in my entire life, my lord. Now, my lord, against me, this version of FIR has been culminated into a charge sheet. And my lord, 490 under section 494, the person with whom the relationship is allegedly established, that person cannot be made an accused. My lord, that is the settled principle of law, and that is the case against me. My lord, I'm backed by.
No, where? Show me the charge sheet. What is the
Yes, my lord,
allegation?
kindly see the charge sheet. The lordship will find the charge sheet from page number 15 on. Sorry. From page number 16 onwards, my lord, Annexure B, your lordship will find the charge sheet, my lord. The lordship will find the 161 statements, my lord, none of them against me, lord. None of them have a single direct anything against me, as the law is very clear against me, my lord.
So what is the charge against you?
494, my lord, and 498A, and both does not attract, my lord. Kindly also page 18.
Yes, I am there only.
My lord, kindly comes to its a handwritten charge sheet, paragraph number 3. So I am submitting the charge sheet of this case, White Shiliguri Women PS case number such and such, dated such and such, under section 498A and 494 IPC against accused number 1, that person, my lord, I am not purposefully naming him. Accused number 2, Srimati Moni Das, that is the petitioner before your lordship. And my lord, may I just be permitted by your lordship to rely on a judgment of this honorable court on this basis.
Yes. That's all. Yes. What is the who is for the state?
I'm for the state, my lord. My lord, it is fact that as per the Hindu laws, Hindu Succession Act, second wife, he will not be treated as a relative. But as per section 498, if the husband treats the second wife as the wife and his relative accepts that, then he will come within the purview of section 498A under the word relative. So here, what my learned friend has stated that as per section 498, only the husband and the relative. There is a decision of the Kerala High Court in 2015, my lord. I'll be citing it, and I've just checked in my, I'll be citing that, man. They have stated, I'll just read out some relevant portion, my lord. From the view of Kerala High Court, the relationship of a man with a woman in a case of a mistress, she cannot get the status of bride. But when a lady enters into the second marriage and the lady is treated as a wife by the husband, relative, friends, or society will be constituted as a relative of the husband for the purpose of section 498A. Of the, and the second marriage with another woman may be treated as void for the purpose of Hindu succession. That is different regarding the inheritance of his property and
Correct.
all. That is different. But in 498, now why the cruelty started? Why she was physically assaulted? The reasons is that this lady, because she had a relationship with the lady with whom he has played away. And in the CDs there, my lord, there are 4 statements of the witnesses, page number 7, 8, 9, and 10. They categorically name the person Money, the name of the petitioner in all the statement under say 161. Even he is named in the affair. It is not that it is an afterthought. It's not that afterthought the name came. It is her name is in the affair also. So at this stage, without going through the evidence, my lord, we cannot come to a conclusion that there is no allegation against him, either by way of law, my lord, a fact, as well as,
Where she was residing?
my lord.
The second marriage, whether she is residing along with the whole family?
My lord, that is as per the investigation.
Well, that's why, where is the evidence that she is
No, that's
residing?
in the CD, my lord.
Yeah.
Charge sheet has been filed.
Correct. See, might be he has conducted the second marriage,
My lord.
whatever it may be.
Well.
Whether she is residing along with the first wife in the same house, or she has committed any cruelty only by saying that she is the main reason. He has conducted, might be conducting the second marriage will not come under the purview of, come under the purview of the 498A.
Then why her name is taken, my lord,
Might
with all the
be.
witness?
That's why I'm telling.
But I'll just check, my lord. The charge sheet has been.
Yeah, they don't go.
Charge sheet has been filed in 2020.
अरे सुना करो.
He has stated that with that lady, she is staying in Bhopal, Madhya Pradesh.
Bhopal, Madhya Pradesh.
All the
Deciding.
witnesses stated.
Bhopal, Madhya Pradesh, how the cruelty has happened to the first wife?
No, after he fled away.
No, that's why he fled
That is in
away.
the FIR,
He left the first wife
my lord.
and fled away with the second, whatever mistress or lover, whatever it may be, and residing in the Bhopal. Correct. So how the cruelty caused upon this wife by the second lady?
If there is one iota of evidence that I was in Bhopal or this person was in Bhopal.
You might be.
What let it be here for once.
You might be in Bhopal. You might be in Bhopal where, see, cruelty, what? 490 cruelty what? The husband went to with the other lady, whether it is a cruelty of the second lady with whom the husband
Yes.
went away.
Yes, my lord. That's my point.
Some photographs are there with the.
Correct. Admit.
This can be compliant.
Now, leave aside the correct. See, it is not denied with regard to conducting the second marriage, residing with the second wife.
My lord.
Amounts to 498A.
And actually, he has received the 41. What my learned friend has missed out, my lord. What it was a very good case that this money 1 he has received the 41 notice issued by the at his address in New Jalpaiguri, near Thakurnagar. So, that is his favor. That is your favor. That is in your favor.
Yes, yes.
Then you have missed that. Prosecutor, we are here for to bring everything the truth. I have stated not complaint. I have stated no, it has not been. Only it has been
Yes.
collected by the.
Anything further?
Normally.
The judgment mirror I have cited kindly. The 494 in transaction, if anything is transferred to the and the weekly.
So and so appearing for the petitioner, so and so appearing for the state. The petitioner has filed the present application under section 482 of the Code of Criminal Procedure. When you filed this, when the FIR was chalked out? 2000? 2020? Okay. Under section 482 of the Code of Criminal Procedure, praying for quashing of the criminal proceeding initiated by Siliguri Women Police Station, case number 191 of 2020, dated 2012-2020, under section 498, capital A, and 492 of the Indian Penal Code, 1860, corresponding to GR case number 55979 of 2020, being charge sheet number 31 of 2021, dated 31st of March 2021, pending before the Learned Additional Chief Judicial Magistrate, Siliguri. Magistrate at Siliguri. Counsel for the petition submit that. Counsel for the petition submit that. On the basis of the written complaint of the wife of the main accused. What is the main accused name? Wife, and the complainant is the wife.
The complainant is the
Wife. And wife of the main accused, namely Narayan Rajak. The police has initiated the efforts above mentioned. Counsel for the petition submit that it is the allegation against the petitioner that the petitioner against the petitioner that the petitioner had married to the to Mr. Narayan Rajak, having the knowledge that he is a married man, and after the marriage, she and the petitioner went along with the co-accused Narayan Rajak at Bhopal and residing at Bhopal. Counsel for the petitioner submit that after completion of the investigation, police has submitted the charge sheet against the petitioner. Against your what is the offense? Both 498A also. Against the petitioner for the offense under section 498 and 494 of the IPC. Full stop. Section 494 of the
494 allegations, my lord, it has to be proved, my lord. It's a non-cognizable case, it's fact. But as 498 is a cognizable, that's where.
That correct, but 494 against the lady.
494 lady.
Does not. Kindly go through this. Cognizance cannot.
No, that's true.
Even
Non-cognizable.
non-cognizable, if even you file the complaint also under 494, only the husband can be entangled under 494.
Their stories treated to be corporate truth and the victim.
Correct, that's why. क्या बोला? Section 494 of the IPC, 498A and 494 of the IPC. Full stop. Section 494 of the IPC reads as follows. Vikarvin. 494. No, अब continue, बता देगा बाद में. Full stop. Counsel for the petition submitted. Counsel for the petition submitted that no case is made out against the petitioner either for the offense 494 of the IPC or under section 498 of the IPC. Learned counsel for the petitioner has relied upon an unreported judgment in the case of Sagari Hembram versus the state of West Bengal and another passed in CRR number 2287 of 2023, dated 19th November 2024, wherein the coordinate bench of this court held that conduct of second marriage is prima facie applicable in respect of the husband of the complainant, and the ingredients of the offences are alleged are prima facie not applicable in respect of the petitioner. Full stop. Counsel for the petitioner further submitted in this the said judgment is squarely applicable in the present case. Per contra, learned advocate appearing for the state submitted that in the FIR itself the name of the petitioner is mentioned, and during the inquiry and during the investigation the police has come, police has found that police has found that the petitioner has committed the offense under section 494 as well as 498 of the IPC. And as on completion of the investigation, the police has submitted charge sheet. Counsel for the state also draw the attention of the statement recorded by the investigating agency at the time of investigation of the case under section 161 of the CRPC. In the 161 of the CRPC also, it is categorically mentioned by the stated by the witnesses that the petitioner went along with the co-accused at Bhopal and has married second time with the co-accused. He submits that though under the Hindu Succession Act, the second marriage cannot be, the relationship of the petitioner with the co-accused cannot be treated as husband and wife, but for the purpose of the provisions of the Code of Indian Penal Code, it can be said that the petitioner had illegally married the co-accused and has committed an under section 494 of the IPC, due to which the petitioner also the accused under section 498 of the IPC, treating that she is a family member of the co-accused. And the learned counsel for the respective parties peruse the materials on the court. Section 494 of the IPC reads as follows. ठीक है 494 यहाँ से लेकर के यहाँ तक सेक्शन 187 188 ठीक वो करेंगे full stop. In the present case, it is the case of the complaint, it is the case of the prosecution that in the FIR, the de facto complainant, that is the wife of the co-accused, has made an specific allegation against this petitioner also, that the husband of the de facto complainant has conducted second marriage with this petitioner and flee away to the Bhopal and started residing with the co-accused. It is also the case of them. Full stop. It is also plain from the statement of the witnesses that the witnesses also stated that the co-accused has married to the petitioner and is residing at Bhopal. If at all the statement of the de facto complainant and other witnesses are taken into consideration, it cannot be said that the petitioner is involved for the commission of offense under section 498A of the IPC. With regard to the 494 of the IPC, the petitioner cannot be entangled for the said case. The petitioner is a lady. 494 cannot be invoked against the petitioner. In the case of Sagri Hembram, the coordinate bench of this court has categorically held that the conduct of the second marriage is prima facie applicable in respect of the husband of the complainant, and the ingredients of the offense alleged are prima facie not applicable with the regard to the petitioner. In the present case also, the present petitioner is the lady and not the husband of the de facto complainant. And as such, the judgment passed by the coordinate bench in the Sagri Hembram Supra is squarely applicable in the present case. Considering the above, this court find that neither section 494 of the IPC or section 498A of the IPC is applicable in the case of the petitioner hearing. Accordingly, the proceeding initiated by the police of PS Siliguri Women Police Station, being case number 191 of 2020, dated 21/12/2020, under section 498A and 494 of the Indian Penal Code, which is pending before the learned additional Chief Judicial Magistrate of Siliguri from District Darjeeling is hereby set aside and caused only with respect of this petitioner. CR number so and so 367 of 2024. The petition is discharged from the bail bond if it's not required in any other case. If it is not, if C is not required for any other case.
One
Get
submission,
from
my lord. My lord, item number 80, my lord. I have some emergency from home, my lord. I just received a call. My lord, item number 80, if it can be taken up tomorrow. my lord.
16.
Tomorrow NDPS. No. দিন সিঁড়িটা দিন থ্যাংক ইউ কোথায় আছে নেমে 2 নম্বর ঘরে হয়ে গেল ওকে বলতো গাড়িতে গিয়ে ওর খাবারটা নে ডিভিশন বেঞ্চে যদি নেমে যায় ওকে বল টিফিনটা গাড়িতে বসে খেয়ে দিবে আর মিথিলেশকে বল আমার টিফিনটা করে দিয়ে যাবে দুইটা আলাদা আলাদা ব্যাগ
কোনটা বল নাম্বার না বললাম এমনি বলি সেটা আমি কি করে বলবো?
স্যার ওখানে কাটলেন কেটে উঠে ফাইলিং এর লোক
হ্যাঁ সেই নাম্বারটা আমি কি করে বুঝবো?
ফাইল আছে
ওখানে তো ডিটেকশন দিতে গেছে। হ্যাঁ ওটা তো ডিটেকশন ওদের কাছে কত নাম্বার সেটা তো মনে করতে হবে কোন জায়গায় রাখলো আমি কি করবো কোন জায়গায় আমাদের তো ফোন নিতে আমরা সময় দিয়ে একটা ছিল করব আমি কোন রকম ফোনের মধ্যে দেব এবং এই একটা কই থাকবে হ্যাঁ খাওয়া দাও পরে হবে দুটো সাজি দাও ঠিক আছে
তো দর্শকদের খানার মধ্যে থাকে তো কইলে কি এই সাইডের পার্টগুলো হ্যাঁ ওগুলো এখানে আছে বারবার ছিল
উপরে চলে গেছে যখন কেন দুটো দুটো ফাইল মানে একসঙ্গে ই করেছিলেন আপনি দিতে করে
And some evidence of that, and then there's no charges for, yeah.
Choose the right form.
Proceedings are interesting.
My lords, I'm for the petitioners.
Yes.
My lords, in this case, I'm seeking quashing of the FIR and the consequent proceedings. Charge sheet has also filed. I'm challenging the charge sheet as well. My lord, this section, the allegations are under section 306 of Indian Penal Code.
306.
6.
Yes.
My lords, the main allegation against me is that the complaint was lodged by one respondent number 2, the wife of the deceased, my lords, alleging that husband's death was the result of abatement of suicide by the petitioners herein. She claims that along with others, the petitioners were running a illegal poker club at one resort in Siliguri, and her husband, who suffered from depression, was invited to play by petitioner number 1 over there. Consequently, the husband, the allegations that the husband of the petitioner lost around 35 lakhs in poker, and thereafter he committed suicide. My lords, may I bring my lords to the FIR? FIR is at page 37 of my petition. And my lord, the type-
What is the relationship with these petitioners and the deceased?
my lord, no relationship.
No
No
relationship.
relationship. No relationship. And my lord, the allegations are completely vague. No specific role has been pointed to anybody. I have annexed the 161 statements as well.
Where is the FIR?
My lord, at page number 37, the typed copies at page number 38. The written complaint is at 37 and the typed copy.
Page number 38. 28.
38. May I read this?
Yes.
I, the undersigned wife of Tenzin Tenduk Fusba, resident of Pani House, Bangalore, request you to kindly investigate the death and circumstances surrounding the death and the circumstances surrounding the death of my husband who passed away on 22nd February 2023. My lords may also note down that the FIR was lodged after 10 days. The incident is the 22nd February 2023. The FIR was lodged on 3rd March 2023.
Correct.
At Blue Mountain Resort, Siliguri, where they run an illegal poker place named Country Poker Place. The place is run by one Dashu. This is the petition number 1, along with Rahul Gupta, petition number 2, and some other partner. On 22nd February 23rd, I came to know that my husband is at that place playing poker on the invitation from one Dashu. The details can be recovered from his call and message records. Following which I called up Dashu, but he did not answer the call, after which I spoke to Rahul Gupta and told him that my husband is not well. He informed me that Tenzing is there at the place and played poker on the credit given by Dashu and lost 35 lakh rupees. Well, all this information allegedly is received from petition number 2 by the complainant. I clearly told him that we are not in a position to pay the money and that the institution run by them is illegal. And if any untoward incident occurred, then he, Rahul and Dashu will be responsible. And Tenzing suffers from depression. My lords may also notice that his wife is saying that he suffers from depression. My husband was to return that very day. He had informed his mother at 11:30 a.m. in the morning. I spoke to Rahul around 6 to 7 p.m. in the evening. But the same night at 2 a.m. when I called my husband, a police personnel answered his phone and informed me that he was found dead in his hotel room. I request you to kindly look into the matter as I strongly believe. My lords may mark this words also that as I strongly believe that after the phone call to Rahul Gupta, they must have pressurized him regarding the money which had abated to Tenzing committing such act. Also, Rahul Gupta had my phone number via which he could have informed me, but neither did he inform me nor is he taking my call since that day. Once again, I ardently request you to look into the matter as it led to my husband to commit such an act. The hotel in which such a thing operates, as well as the people running such an establishment, are responsible and abated to my husband committing such an act. This place is, if not monitored, closer investigation will end up claiming many more lives. This is the crux of the allegation, my lords. Thereafter, my lords,
So she is the wife
this is the
of the
wife.
deceased.
Wife. The wife has been served several times, but she has not appeared till date. Thereafter, my lord, petitioner number 2 was also arrested in the same case on 22nd 9 2023. After a period of 27 days, he was released on bail by the
So he found dead on 28th of February. 22nd of February.
No, on the same 22nd of February.
Correct. He
yes.
found dead on 22nd of
Yes,
February
ma'am.
in the night.
Yes.
In the night. And what has happened to the after this?
My lord, investigation was conducted.
Any unnatural death case is registered. UDFI is not registered.
UDFI was there.
Yes, where is that?
UD case is at page 55. I have a translation also, my lord.
You have a translated copy?
Description part.
Which one?
Just UD case, page number 55. Translated.
Okay, that is the different.
Yes, then what has happened after this UD?
My lord, so postmortem was conducted.
Hmm.
My lord, the postmortem report is at page number 49. My lord, that the last, although that was assessed as a result of finding intermon.
Where is?
Last, my lord,
Cause of death was auspicious as a result of hanging. Antemortem. Antemortem. Yes.
My lord, if my lord would like to go into the details of, I mean, at some point of time, I'll come to that later.
What you want to say?
No, my lords, I mean, I have from Modi's books that this is a case of 306. They were trying to at some point say that it's 302 for that reason. That's not required. If my thereafter, my lords, the petitioner herein, petition number 2 was arrested by the police investigating officer.
When he was arrested?
He was arrested on 22nd September 2023.
September.
Yes, my lord.
Okay, so now the first see, what is the procedure? If the UD is initiated, what has happened to the UD?
So that I'm not aware of. They will be able to.
No, it's a case of suicide.
Correct. Case of suicide. Once the police has started the UD, how the UD is converted into the FIR?
Well, at once, because at the first stage, there was no complaint.
Correct. That's
It was
why
an
UD.
unnatural death, right, my lord?
Correct.
Unnatural death. Now, later on, the complaint was filed.
Hmm.
So automatically, my lord, when the complaint was filed, this UD case was tagged with the specific case was started, my lord.
Yes.
Have you finished?
No. I am putting this only question. So in the UD only this this contents.
My lord.
There was nothing in the UD.
No, whatever was there in the it is there.
Where is the inquest? When the inquest was
I have
conducted?
received this documents as a part of 207 CRPC.
Well, so
My lead-
inquest because UD
Yes, my lord. This-
UD started then the first
Inquest.
duty of the investigating officer with regard to the inquest. Where is the inquest?
My lord,
Because he has described the injury on this body of the deceased. So where is the inquest?
My lords, I have only this page that I've annexed along with the petition. My lords, I have only.
When I'm holding the CD, my lord, inquest.
Where is the inquest?
I'll just.
And when the inquest was correct, yes, page 59, come to the page 59.
No, 59 of my CD.
Page
It is your CD.
My lord.
No. It is application.
Oh, 59 of them in
Page 59, 55.
55.
My lord, that's the report. You
55.
Yes,
That is
yes,
the
yes, ma'am, description of the body. That's-
description of the
yes, ma'am.
body.
This is what I've given you a translated copy of, my lords.
So this is an
That
investigation.
is in 84, page number 84 of the CD, my
This is
lord.
what I've given you. earlier.
Page 84 of the CD.
So after this, what has happened? Nothing.
No, when the, my lord is written, Siliguri case, UT case is there. when
UT
inquest was
case
done-
initiated.
My lord. Then thereafter, my lord, the complaint was lodged.
Complaint was lodged on 3rd.
Third.
So
The specific
with
case
regard
was
to the
started
20
thereafter.
that's why the 23 to 2nd from this, what this investigating officer has done in the UD case.
But he has collected the postmortem report.
What he has done then?
No, he has done, every day his investigation is there from page number 88, my lord, of the CD. Page 88. I'm holding the original, this is the certified copy, my lord.
Page 88.
Page 88.
173, yes. That's I want to know. So they continue 23, send the email message. Close SCD 23.
Thereafter, page 91, I received the email message from Mayor Kalunasha Pradhan Nagar regarding above noted duty case. Specific case has been started. Page number 91, my lord. Specific case has been started, White Badan Nagar PS case number 140, and corresponding Siliguri PSUT case number also White Badan Nagar. He have paid supply of the SCD along with the PM report of the deceased, namely Tenjing Lendu Kutsabra district. After receiving message, I contacted the TMDC and PM report and got the PM report. Then it was tagged, my lord.
This is,
Specific case. UD was
no, that's why I want to see. This is UD started on 23rd.
my
And
lord.
this is a 4th March,
My lord.
correct?
Case dated 4th March.
Hmm?
Case
Third-
3rd March.
third March 2023.
No, that's why kindly come to the 90th. Your UD CD has started, UD is 84, correct?
My lord.
UD is 84 and Chalan use of winner dead body, that is okay.
My lord, in UD case, the complaint is different. Indojit Chakraborty.
See,
And in UD
as
case
per
also, there is
that
a
is-
FIR case. my lord.
That's why the prosecution every time fails. What, once you started the UD case,
My lord.
if the UD case continue till the final report, it will go to the subdivision magistrate
My
and
lord.
it will end. Final report, UD case registered, UD and then what, that's why I am
After the UD
confused.
case was started, my
That's why,
lord,
no, that's why I am confused with regard to what the 84 is the inquest.
in case.
Correct, it is the inquest.
My lord.
If inquest has, where is the UD FIR? UD case, so the police station has to, this is the discretion, this is the inquest. And inquest, I kindly see inquest, this is the first inquest.
First interest.
In the first inquest, that is the main thing which has to ascertain with regard to the injury and position of the body.
My lord.
Kindly come to your opinion, this all these things. Opinion of the witness, cause of death, do, what do? As per Sarpat report.
Hmm.
What is the Surapat report?
With inquest.
So what is the report? What is the opinion? Opinion of the Panchas should be either this is the suicide or there is a chance of circumstances of the murder or any thing has been done, illegal thing has been done. Kindly see, that's why this serials has been given. Opinion of the witness of the cause of death.
My lord, when
Opinion of the police
UD case, when a UD case is started, and if it is found that it's the case of suicide unnatural death, then the case automatically it closes.
That's why I'm
So
telling.
it's written in the UD case, investigation commenced on paragraph.
That's why I'm
number five.
telling. That's why I'm telling. First, the UD case is started. Once UD case is started, that is the UD FIR.
FIR,
UD FIR. This is not a UD FIR.
No,
This is an inquest.
inquest.
Where is the UD FIR?
It's written, the complaint is one Indrajit Chakraborty.
Where is that?
Page, paragraph 2, my lord.
Where is the UD
What?
FIR?
That is in page number 83.
Correct. So this is the report. That
This
body
is
of
the
the
UD.
deceased, namely turning so and so so and so. Sikkim home so and so so and so. So this has received.
My
Correct.
lord.
And thereafter the inquest was
My
conducted.
lord.
And after the inquest, then the body was sent to the postmortem.
Postmortem.
Postmortem report received.
Received.
When the postmortem was received,
Page number,
49.
huh?
In my petition,
PM is page number 87. of this.
87. This
My
is a postmortem. Whether this postmortem was received by the UDF in the UDFI or in the main case.
UDFR.
UDF when it was.
But it
received-
was, when it was done, the UD number is there. But when it
Correct.
was
Where-
collected, my lord, already specific
Okay,
case was started.
UD 73.
Yes, yes, my lord.
UD 73. It
My
is
lord.
received the
My
UDFI.
lord.
Correct. Now it is continued. And this is the.
This is the daily to daily investigation. In the
Yes,
meantime, they
continue.
received a FIR from the wife of the deceased.
Continued.
And they started a specific case. They investigated, they filed charge sheet against this petitioner as well as another person, my lord. Now, this petitioner, however, he got an anticipatory bill, and that time he thought that I got an anticipatory bill. I have acquired the right to file a petition under section 482 for quashing.
Hmm.
Because when a person gets an anticipatory bail, he thinks that I'm absolutely innocent in this case. A false case has been lodged against me, so I should pray for an application under section 482 of the CRPC. It's not that, my lord. There's sufficient materials.
Let me see.
He may be granted anticipatory bail, but it's not a case of quashing. Abatements is something which cannot be proved without evidence. 306. Abatements are many types. There are some abatements are not always direct.
Okay.
There are
Yes.
indirect abatements
Yes.
are also there.
Yes, start.
My lords, after the filing of charge sheet, 207 papers were supplied to us. Thereafter, we received 161 statements and postmortem report and other documents.
So what are the ground for
So, my lords will, tell you
For
the
quashing?
161 statement, my lords, once. My lords, from page
page?
page 63 onwards, I have also given you a translated copy, my lords, in English,
Page 60?
page 63 onwards.
Yes.
My lords, the translated copy, my lords, will tell you all the statements.
Hmm.
My lords, first is the statement of the wife of the deceased.
Yes, which page?
Page number 6, my lord, of the CD.
63, yes.
My lords, the translated copy, my lords.
Yes, English is there.
So
You
in
don't need
response,
translation copy. It's written in,
In
my lord,
response
go
to
to the CD
inquiry,
also, page number 6.
I state that my
It's
name-
very easy to read, my lord.
Page number 6.
My lord.
I,
It's
Yes,
written,
tell me.
आपका जिज्ञासा में बोल रहा हूँ. It's
Yes.
very easy.
Yes.
may I read in English, my lords? In response to your inquiry, I state that my name is Tashi Palmu Namgyal and I'm a resident of Sikkim. I'm the wife of late Tenzing Tengbu Kushba. Two individuals, Rohit Gupta, Rahul Gupta and Taso, had called my husband and invited him to play poker in Siliguri. My husband checked into Blue Mountain Country Club in Siliguri on February 18, 2023 to play poker where his illegal poker games are held. On February 21, 2023, I tried to call Tenzing. but he
Where
did
from
not-
you're reading?
Well, the translated copy.
Not required. You read
That is
the
English.
original copy now. You read the
English.
original.
Right.
Who has translated?
You got
How
the
can
English
I-
copy. You
expression
have not
has-
been served with the 161 in English. They are having the CD in the English of
No, it's in
63.
English.
63, page
I'll
63.
read out for you.
आपका जिज्ञासा
हाँ,
मैं बोल रहा
क्या-
हूँ कि
yes.
मेरा नाम ताशी पालमू नामग्याल,
हाँ.
मैं सिक्किम का रहने वाला हूँ।
हाँ.
मैं लेट तेंजिंग तेंदुल कुब्जा का वाइफ हूँ। मेरा हस्बैंड को रोहित
गुप्ता and दाशो
दाशो केजो नाम का दो आदमी फोन करके सिलीगुड़ी पोकर खेलने के लिए बुलाया था। मेरा हस्बैंड
पिकनिक
पिकनिक 18/2/23 तारीख को पोकर
खेलने के लिए गया सिलीगुड़ी।
पिछले तारीख को
पिछले 18
अच्छा, पिछले 18-12 को।
तारीख को पोकर खेलने के लिए सिलीगुड़ी ब्लू माउंटेन कंट्री क्लब में गया, चेक इन किया था, जहां पे इलीगल पोकर चलता है। 21/2/2023 तारीख को मेरे को मैंने तेंजिंग को फोन किया था, बट वो फोन नहीं उठाया, इसीलिए मैं बाद में राहुल को फोन किया। तब राहुल मेरे को बोला तेंजिंग अपना सारा पैसा हार गया था और तेंजिंग केजो से 35 लाख रुपीस क्रेडिट लेके ही हार गया। ब्लू माउंटेन में जो इलीगल पोकर होता है वो दाशो और राहुल ही चलाते हैं। 22 तारीख को मुझे एक पुलिस पर्सन से पता चला कि मेरा हस्बैंड ब्लू माउंटेन रिसोर्ट का 113 नंबर रूम में मरा हुआ पाया गया है। मेरा फुल डाउट माय लॉर्ड्स, अगेन
फुल डाउट है कि मेरा हस्बैंड का
सुसाइड से के पीछे केजो और राहुल का
करेक्ट
पूरा हाथ है।
यस देन
Similarly, my lord, this is second state. My lord, no specific allegation has been made. No specific information is by them. She's only on mere suspicion. She's saying that there was an illegal poker club game going on in which he lost money and therefore he committed suicide, and these two people have abated his suicide.
Correct.
There's no particulars as to why, where, what happened.
Correct.
My lord, similarly, all other plus, my lords, no seizure about even a single poker chip has not been, they have not even been able to establish that a poker game was actually going on that day. Even if we assume a poker game was going on, even then the section 306 of IPC will not be applicable to the present petitions, my lords. My lord, the second statement, page number 64,
Hmm.
is of a friend, Karma Jigme.
Hmm.
आपका जिज्ञासा में मैं बोल रहा हूँ कि मेरा नाम कर्मा जिग्मे, मेरा फोन नंबर दिस इज तेंजिंग, मेरा रिलेटिव था। तेंजिंग का वाइफ से पता चला,
Hmm.
he came to know through the wife of तेंजिंग। पता चला तेंजिंग राहुल एंड केजो के बुलाने से सिक्किम से सिलीगुड़ी पोकर खेलने आया था। वो ब्लू माउंटेन रिजॉर्ट पे रुका हुआ था। पोकर में उसका बहुत पैसा लॉस हुआ था और केजो उसको 35 लाख और 35 लाख रुपीस उधार दिया था। वो सब पैसा
हार
इस
गया।
पोकर पे हार गया। बाद में जब केजो राहुल पैसा को लिए चाप दिया तेंजिंग, तब सुसाइड कर लिया। मतलब दिस एंटायर थिंग इज अ hearsay. Hearsay, not even first information from an eyewitness.
Yes.
His wife said.
Yes.
Third statement is an identical statement, my lords. It's again from a relative friend. आपका जिज्ञासा में मैं बोल रहा हूँ कि मेरा नाम तुबदेन ग्यात्सो है, मेरा फोन नंबर ये है। तेंजिंग मेरा रिलेटिव था, वो सिक्किम से सिलीगुड़ी पोकर खेलने के लिए आया था और ये पोकर खेल के लिए राहुल गुप्ता और दाजो केजो उसको इनवाइट किया था। ब्लू माउंटेन पे इलीगल पोकर खेलते हुए तेंजिंग अपना सारा पैसा हार गया। उसके बाद केजो उसको 35 लाख रुपीस उधार दिया था, जो वो फिर से पोकर में हार गया। जब वो पैसा के लिए केजो और राहुल उसको के ऊपर प्रेशर किया, तब तेंजिंग सुसाइड कर लिया। उसका सुसाइड के पीछे पूरा दोष राहुल और केजो और ये इलीगल पोकर का है। मतलब the fourth statement is another same. आपका जिज्ञासा में मैं बोल रहा हूँ,
All are same.
Same.
Yes.
Then there are two witnesses who are the one receptionist and another housekeeper of the hotel. Both of them have just said that this person was found dead in the room, and nothing of no utterance of Rahul, no utterance of Kezo, no utterance of any illegal poker happening, no utterance of having seen these three people together at any point during the day or night or at any point of other time. This is the 161 statement on which the prosecution is trying to base a case of 306 IPC against the two petitioners here.
Correct.
My lord. And other, my lord, is look at the seizure list. My lord, seizure list is at page number. My lord, page number 57 is the seizure list.
Yes.
My lord, description of the seized articles. One blue color hotel register of the Blue Mountain Country Club Resort. Serial number 1 to number this one original notary certificate duly powered by advocate Kanchan bearing this. One Anand Kumar, in between Anand Kumar Prasad and Jimmy Om Bhutia and Rahul Chaurasia. None of these have been made an accused, so I do not understand the relevance. One Xerox copy of notary certificate of deed of lease bearing number. This is in between Anand Kumar Prasad.
That is what are the documents they have seized, they have taken. What is the incriminating material in the seizure? What are the incriminating material?
Absolutely nothing. How 306 has been made against me, I do not understand. There's
So
nothing
what is the conclusion of the investigating officer? How it has been, how this death was occurred?
306 I see my
306, okay. 306, it might be they have committed strangulation, by way of strangulation. If it is a strangulation, what is the evidence the police has collected? Yes, sir. Okay, what is the case of the police?
My lord, give me an opportunity.
Yes, I will give. Let me understand what the police has made out the case. 306, okay. As per the case, the body was lying in the hotel. The wife allegation that he went to the playing poker and he has lost 34 lakhs as informed by the friends. So she has having doubt with regard to the two friends, and all the persons stated that this is the same thing. So with regard to the cause of death, postmortem report, antemortem, correct. So what is the cause of death? How the police has filed the charge sheet? Let me understand from the state, then I will see to that. Yes.
In this case, police has seized certain lease deeds which were executed between the owner of the Blue Mountain Resort as well as the wife of this petitioner. There are several agreements statute and every 1 year it has. And in that case, it's a fact that in that case, illegal poker was going on and people used to come from Sikkim because Sikkim are not allowed to play in Sikkim. Wherever it's like a casino, but it's called
Correct.
poker. As the locals are not allowed to play, they come to West Bengal and they play there. So there they used to play. Kaju is also from Sikkim. They used to call those persons, they used to play and they used to stay in the hotel rooms. On the hotel room, several used condoms and things. So used condoms, he was staying there alone. That means there was something else, some females were regularly coming there. Now where there after there it was a bar also as per the agreement, the drinks has to be supplied from the bar. And here your whatever it was, Kajo was the main person, his wife, only the name of the wife the business was. So Kajo used to supply, first of all, he used to give the liquors to the persons.
The hotel belongs to whom? The hotel belongs to whom? Hotel belongs to whom? Anand Prakash.
There was a lease. Now thing is that he was confined. He was confined with the room and he was asked the amount of money was asked from his wife. That you pay that amount.
Who?
This amount to his wife, the deceased wife was asked to pay the amount, otherwise they don't release him. This is actual fact.
Where is the evidence?
Now, my
Show
lord,
me.
my lord, the evidence is of that. Now,
That's why.
161 statement. If my lord goes to the 161 statement and there are other 161 statement of the hotel staff. Now they have stated that, okay, fine. Now regarding the postmortem report, no doubt, my lord, it's a case of suicide. So as per the procedural report, now thing is that his involvement, Abetment, why he has committed suicide. It's not a fact that he has committed suicide without any reason. He has committed suicide as this money was supplied and there was a constant pressure upon him to pay that money back.
So that's why you show me what is the evidence.
That is in the FIR, that is in the 161 statement, my lord.
Will you prove this statement in the in the 306 case? Yes, where is the demand? Where is the phone call? Where is the evidence that it was called in my presence? They have demanded the amount. This is not the you have to put the strict proof. How you can examine? How you can examine the witness? How you can prove the case? Where is? That's why I'm telling. Show me the incriminating material against the accused persons. Yes, these are the incriminating material. They have called the victim and the wife of the deceased and asked rupees 34 lakhs and informed that if she will not pay the amount, he will be detained in the room. And subsequently, it was found that he was dead.
Also, the certificate under section 65B.
He was lying dead. That's why the CCTV footage, evidence, that all death is not denied. Found him dead, not denied. But with regard
of Abetment, when there is any suicidal note, my lord.
Not suicidal note.
When there is no suicidal note, in case of there are 6 Abetment to commit suicide, my lord, in that case, without going to the evidence, how can the
That's why show me what evidence you want to prove in the trial.
jurisdictional court, my lord?
Sir, you cannot go beyond your CD. You show from the CD what are the evidence you will prove from the trial court. Show.
That's fine and cognizance has been taken.
Correct.
Cognizance has been taken.
Correct.
First of all, they could have raised this point there.
Not
There are two
necessary.
options, either cognizance has to be taken or the matter can be end up there, or it can be sent for reinvestigation. So there are 3 options available to the magistrate. So magistrate
For
has
the-
taken cognizance.
For the reinvestigation, why the accused can say the reinvestigation?
So
Then
magistrate himself can say,
he has accepted that.
yes,
That's
it.
accepted that and committed the case to the sessions. Sessions judge. What is the stage of the trial?
The 7 papers were submitted to us. We are enjoying a state.
Then 207, after getting the total document, they filed an application.
Has to be examined. Yes, it is
That's why, sir.
Supplement,
Sir, please you show me which document, which evidence the prosecution is relying upon so that the case can be put in trial and it can be placed. Show me the document.
No, fact, my lord, in that case, I have to call the IO and I have to inquire why, under what, on the basis of what document.
You are having the latest judgment of the Supreme Court. Just 15 days before. Which judgment you are relying upon?
Others versus state of.
Which year?
This is 2017.
No. Latest Latest 2-3 judgment has been delivered by the Supreme Court. Because I am not I am not taking the criminal jurisdiction, otherwise I could have been thick.
And one I have for 2025, but that came after discharge application was rejected by the.
See, I appreciate with regard to the quashing of the criminal proceeding, it is rarely, but fact, but the prosecution has to satisfy from the record. These are the evidence which has to be in trial, and in the trial it has to be decided. Unless you show the prima facie what are the materials, only 161 मेरे को शक है, शक तो हर जगह होता है. Where is the materials you collected? You have also not sent the body to the postmortem again. Not sent. Then postmortem report is suicidal. Then no. See, commit suicide. It's different thing. The body was lying there. Abatement. Correct. Then all the angles, once it has come to the knowledge of the police with regard to there's something is there, then all the things has to be taken into consideration. Visra has not been taken. Where is the report? What is the report? What is the FSL report? As per the UD, the FSL team has come. Then so show me the document. Yes, this is the 2 documents, or this is the evidence which we have to prove on trial. Which document you are relying upon, or which evidence is you are relying upon? Please, you sit with the investigating officer. Come.
I know they'll bring the latest judgment also on that.
Go through. There is a relation, I think a month or 15 days before. Recent judgment on 306. How it is to be dealt with.
We have taken a lot of other judgments, so we do not think that's one.
So suffering for the petitioner, so suffering for the state, counsel for the petitioner argued at length. Full stop, counsel for the state pressed for time to take instruction. Case is adjourned. Let the matter appear on 16th.
Grateful, my lords.
Yes. Yes, where is the which order you challenge?
But I'm challenging the FIR itself.
FIR. Quashing.
Yes.
What is the section?
420 and 406. A very peculiar case kindly takes up the complaint at page 16.
Page 16.
Yes, ma'am. This is the petition under 156(3) of the CRPC, in pursuance of which this was treated as the complaint and case was registered. My lord, this to me looks more like a plaint of a suit than a criminal complaint. Kindly takes it up.
Yes.
It says that I'll read out from para 2 onwards, that the complainant bought one vehicle bearing registration number such and such, engine number such and such, chassis, in the year 2017 of Mahindra and Mahindra company through the help of finance company, namely SREI Equipment Finance Limited. 3 says that due to the financial crisis in the year 2020, the complainant proposed the accused number 1 for the sale of the vehicle, and the accused number 1 also agreed in the proposal of the complainant and agreed to pay 9,85,000 cash to the complainant and agreed to pay the rest amount of 19,38,324 only as down payment to the company accused number 2 as 82,658 EMI per month. Thereafter, it says that getting the proposal from the accused number 1, the complainant agreed upon it, and as per the proposal, a sale deed was executed on 19/9/2020 in front of Notary Officer Ganesh Chandra Shikdar and Advocate Ashit Bondhu Shorkar, sale deed bearing deed number such and such dated 19/9/2020. 5 says that as per the sale deed, the complainant handed over the mentioned vehicle to accused number 1, and the accused number 1 took the vehicle to his house. 6 says that on 12/2/2023, the complainant over telephone contact, my lord.
As per the sale deed, complainant handed over the mentioned vehicle to accused number 1 when?
Doesn't say that. Doesn't say that. Then he skips 3 years. My lord will kindly take the at para number.
That's why there
4.
is no money suit.
Yes.
Yes.
So at para number 4, the date is 19/9/2020. Thereafter, para 6, 12/2/2023. The complainant over telephone contact with the accused number 1 and told him to pay the rest EMI to the finance company, and then the accused number 1 threatened the complainant with dire consequences, and he also told he will not pay the amount to the finance company. This is, my lord, the crux of the complaint. There is no allegation of inducement, no allegation of cheating, no allegation of ultimate misappropriation of the property. On the basis of this, an FIR under section 406 and 420 has been registered.
Where is the FIR?
My lord, this is the FIR. This has been treated as the FIR.
Then,
After this, my lord, to my knowledge, there is no progress in the investigation for the last 2 orders.
so you got the anticipatory.
Yes, sir. We got the anticipatory bail. I will not trouble your lordship with the flood of judgments, just 3 sides.
What is the investigation completed?
Investigation completed.
You are having CD?
My lord, I hold this.
What is your instruction?
Instruction is that, my lord, though we are going after at a glance to the FIR, it seems the matter is civil in nature, but it doesn't have a bar on the criminal courts. There is a case of cheating, so obviously at this stage it cannot be questioned.
Where is the charge sheet? Where is the witness?
But this is the original.
Why all the things is putting burden upon the courts? Time and again the Supreme Court telling.
Litigants, they want relief, my lord.
Correct.
That's why this things are happening, my lord.
What the charge sheet says? Because your charge sheet, your police also not coming with the total in the email.
So charge sheet, it is a charge sheet.
In the whole of that.
Charge sheet, no, we put in charge sheet, no.
There is no progress in the.
Progress in the sense after you got the bill, charge sheet has not been filed, my lord.
Charge sheet not filed.
No, my lord.
Not registered in the year 2023, today we are in 2025.
Correct.
No progress.
23, 25.
Because there is nothing in this case, which is why maybe
Visited the PO.
That's company should have come. No, because that is number 2. And that's something. They are also there.
After 2011, after Norman, nothing. And your IO is so busy, he has gone forward 4 years forward.
No, this is the.
And you see that your IO has signed the this report 27/11/28.
23, my lord. This is a case of 24th April.
But your IO has signed 28.
No,
Kindly see that.
my lord, please, my very handwriting, my lord.
No, it is clear cut. It is not the handwriting.
Not on one point I stand corrected, the bail was rejected. The anticipatory bail was rejected at that stage.
Lordship, may
You are appearing for?
defect of government.
Yes.
Lordship, kindly see page 13, paragraph
13
5,
of the application.
application.
Yes.
Paragraph 5.
Yes.
41, 3 times given, he has not given. If after investigation, police feels that it is a matter of FRD, that can be given. So let him cooperate with the investigation.
It is not the case. He is not cooperating with the investigation.
Lordship, that is, their anticipated bail was rejected.
Initial, then
Initial.
Then we have not approached this on.
Thereafter, Lordship,
you are not on bail.
No. Lordship, kindly sees
Good.
one another
That we
page.
have filed this Quashing up.
Lordship, kindly see
Because
another
crime
page.
space, there is no case.
So I am
This is-
passing an order. You surrender first.
Milord, this is, Milord, if I, just give me 5 minutes. This is struck by the first principle of Bhajanlal, which says that if on the face of the FIR, it constitutes no offense.
But binding upon
Wait.
this court of the division bench order.
Lordship, may,
Division bench was exercising jurisdiction under 438.
Might be, but that's why
Actually,
you,
not in a
till that,
jurisdiction of-
you're not cooperating with the, you're not, you have complied with the 41A.
Lord, after that.
That is
I believe
recorded
we
in
have
the order.
proceed After that,
Not necessary.
Lord will see from the case diary.
Lordship,
Lord, I'm
kindly,
only FI.
And what
kindly
your
cease.
police is, what your police is doing, he has, his anticipatory bail is rejected there, what you are doing?
They are absconding, my lord.
So absconding.
Lord, there is no prayer for warrant, I believe.
Lordship, kindly, see page number 5, paragraph number 5 in application.
So and suffering for the
Lord,
petitioner, so and
if I may.
suffering for the state,
Lord, just
so
give two
and
credit.
suffering for the different, defective complainant. The petition has filed the present application under section 482 of the Code of Criminal Procedure, read with section 401 of the Code of
Lord, if I
Criminal
may just
Procedure,
Rely on two judgments.
challenging the order, challenging
judgments.
the proceeding in connection with GR case number 778 of 2023 arising out of Calcutta Police Station case number 178 of 2023 dated 27th of April 2023 under section 420/406 of the IPC pending before the Learned Court of Chief Judicial Magistrate. Police, the counsel for the petition has drawn the attention of this court to the complaint made by the complainant under section 156(3) of the CRPC before the Learned Court of ACJM2 at Alipur and submit that the alleged complaint shows that the dispute is pure in civil nature, and instead of filing the civil case, the de facto complainant has initiated a criminal case against the petitioner. The counsel for the petition submits that the case has been initiated in the year 2023. Till date, no progress has been done in the investigation and no charge sheet has been filed. Police counsel for the petitioner submits that prima facie it is found that no case is made out under section 406, 420 and 406 of the IPC. He submits that and prayed for quashing of the proceeding initiated, criminal proceeding initiated against the petitioner. Per contra, Learned Counsel for the state submits that the investigation is still going on. He submits that for the purpose of investigation, the police has issued, the investigating officer has issued notice under section 41A of the CRPC to the petitioner, but the petitioner failed to comply with the provisions of section 41, failed to appear before the investigating officer in spite of receipt of the section 41A notice. Police stop. Learned Counsel for the defective complainant has brought the notice of this court to the order passed by this court in an application filed by the petitioner for grant of anticipatory bail being CRM within bracket A of 566 of 2024 dated 20th August 2024, wherein this court has categorically held that, inverted comma, while it is true that the dispute is preliminary civil in nature and sections 406 and 420 of the Indian Penal Code cannot be added in the single FIR, comma, this notes that the petitioner has been issued notice under section 41A of the Code of Criminal Procedure on 3 several occasions, but he has not responded to the same, inverted comma close. Police observing the above, the honorable division bench of this court has rejected the application for grant of anticipatory bail. Police stop. Today also, the Learned Counsel appearing for the state has brought to the notice under section 41A of the Code of Civil Procedure and submit that in spite of the reminder issued to the petitioner and the petitioner failed to comply with the provisions of 47 of the Code of Criminal Procedure by appearing before the investigating officer and cooperating with the investigating officer. Consider the above, this court find that at this stage there is no ground to set aside, no ground to pause the proceeding. Full stop. Cause the proceeding accordingly CRR number 415 of 2024 is
Directs me to surrender for the trial.
surrender. It is
Lord, as per your direction, I'll surrender. Then I may have a protection. Lord, kindly consider that much.
full stop. The
That you can do.
petitioner, na soul. the petition is directed to surrender before the Leonard jurisdictional court within a period of 2 weeks from date.
That is the question they never rejected. That is the reason the IR must submit the charge sheet. Because the charge sheet is submitted 406 they will directly to the next report and then up to the. That is the reason why I should not. But this is late. Because it is rejected.
Yes, next.
Hello, for the petition. Hello, I was, on the last occasion, I was granted leave to file supplementary affidavit because an untoward incident has happened after filing of this application. The only child of the petitioner has succumbed to death. This is the.
What is this application?
My lord, I have challenged the order of the trial court, which is at page 95 of my application, whereby the trial court in regional application has reduced the quantum of maintenance towards the child, the disabled child. And that I have challenged here, but subsequently after filing of this,
You are the father.
I am the mother.
You are the mother.
Yes,
A mother has filed this application
yes, my lord.
challenging the order of maintenance.
Yes, my lord.
Where is
No,
the order?
no.
Where is the order?
Order is, the original order is at page 92, my lord, starting from page 92.
92.
Just
The petitioner Pinky Banning Day. You are the petitioner,
yes, my lord.
Pinky.
Yes, my lord.
Awarded with the monthly maintenance allowance of rupees 10,000. With a child couple, namely the money
Page 93
get
is the
5,000.
order, my lord.
So you are not agreed with this order?
My lord, this was in my favor.
Correct.
Now the opposite party preferred a regional application, which is under challenge before this court, my lord.
So you are agreed with this order?
The 95, as page 95.
Agreed
by that order. Whereby the quantum of maintenance was reduced in case of the minor child.
Where is that?
Page 95, my lord, of my
Yes. This is of the session judge. Session judge in an appeal.
Yes, madam. Criminal revision number 42 of 2020.
This is filed under which 150, 125?
Yes, madam.
No, this
Order, my lord. 34, section 34 of the DB Act.
DB Act. Under the DB Act, the revision lies. Correct. So how the session judge pass an order under divisional jurisdiction?
That
You have not taken that stand.
that is the thing I have taken here, my lord.
You have taken the that. Where is the ground?
Moreover, my lord, the order passed by the trial judge was upheld by the Calcutta High Court. Was upheld that the quantum which was decided for the treatment of the child, medical expenses was upheld by the Calcutta High Court. How the session court can reduce that in appeal? Kindly come, my lord, because there are series of incidents which I have to place.
Yes, place the 95. Place the order 95.
Yes, my lord.
This is a one-page order.
Yes, ma'am.
In the revision.
Yes, ma'am. Kindly see in the middle, my lord, the operation of the impugn order dated 10th of June 2024, passed by the learned Chief Judicial Magistrate Kujbiar in miscellaneous case number such and such shall remain stayed.
This is a stay order. Where is the final order?
No, after this, the matter is pending before this court, my lord, honorable court, and this order has been stayed.
So you are challenging the interim order.
Yes, ma'am.
This is an interim order.
Yes, ma'am.
Total amount is per thousand. Goes to pay rupees 8,000 per month. So yeah, he has been directed to pay 8,000
Yes,
instead of 13,000, 11,000.
No, my lord, 11,000 was passed by the interim order.
So
Earlier it was
you
under
are
15,000.
page 93, you come to the page 93. That is the final order of the magistrate.
Yes, my lord.
Correct. Final of
10,000
the,
and 5,000.
huh?
10,000.
10,000 and 5,000 is a 15,000.
15,000.
Correct. This order is challenged. And in the revision, that is the, you are telling that is a 95. So and you have filed the revision against the 95.
Yes,
Where is the original certified copy of the order?
That's the
Where is the original certified copy of the order?
in the application, my lord, revisional application.
I am going through the revision application. Page 95 is the Xerox copy. Where is the certified copy of the order? Have you taken leave for admission of this revisional application with the said? Okay, page P13. Yes. So 10th June. The operation of the impinging order 10 June passed by the London Chief Magistrate census shall remain state. The petitioner goes on pay 8,000 per month. Correct?
Yes, my lord.
Per month to the OP and 3,000 per month to the child, totaling 11,000 instead of 15,000, 11,000. So yes, then what has happened? Now you file this revision application.
I filed this revision
Huh.
application, the child.
Now
died in between.
child passed away.
Yes.
Yes.
Child passed away, my
In want of medical, they cannot bear the medical expenses and as such the child succumbed to death, man.
Hmm.
Now, my lord, I have come, I was granted leave by the earlier bench to, since there was a change of circumstances.
Yes, you
to
filed
file.
this. Correct.
Now, I am claiming, my lord, a compensation as well as my lord, just compensation, my lord. because he is not
Compensation
paying.
of?
What compensation the tune of rupees 50 lakh overall, my lord.
In the revisional application.
In which position?
In the revisional application.
My lord, the maintenance, in spite of several orders, not a single penny was paid by the husband.
Go for the DB Act
Execution.
31.
Execution, my lord.
Execution, not execution, criminal
Until and
proceeding.
unless this, then
You are
this order has
having
to
the
be
you are
enforced, my lord.
the 125 or DB Act. DB
Both,
Act.
my lord, there were two applications, my lord, 125 and DP Act.
DP Act.
Now the DP Act is prevailing, my lord. at
So this is a
present.
DB Act.
Yes, my lord.
So DB Act has been passed, but he is not paying the amount. So go for the 31, initiate a criminal action, 31. Can't he go to 29 or 31 something?
Until this interim order is set aside, how could I proceed, my lord?
What interim order? 11,000 he has to pay. You can go for the 11,000. With regard to the 4,000, the court can decide subsequently.
My lord, not
So
a-
now what you want?
let this order be set aside, my lord, at the direction we given to the trial court to hear me out. Fresh. Because there is change of circumstances, so let a fresh hearing.
What you are doing?
My lord, the husband is the teacher, my lord. My lord.
Teacher and
My lord, he
and
paid-
the minor
he
child
get
who was
paid.
suffering from
My lord,
ailment and
my lord, child already expired, my lord.
for your
Treatment cost already given.
what cost you have given? Show me the paper. Other I will pass herein now.
My lord.
In the revisional application with regard
Give
to.
me liberty to 2 days ago.
Sorry, I am passing herein now with regard to how much amount he has spent for the treatment.
My lord,
And I am setting aside this
we
order,
cannot
demanding.
spend a single penny because there was no money.
My lord,
At the instant
instruction.
child
Let me-
birth
let
takes
me
birth.
Where
my
is
lord.
your where is your client?
Client is today not come.
The
My lord,
father
my lord,
abandoned the child
my
because
lord,
he
kindly,
was
kindly
mentally retarded.
give me instruction
For what?
for 2 days.
For what? What you will do within 2 days? You lost your child also. Now what you will do within 2 days?
My lord.
You are the man of this planet.
My lord, I also submit the opposition, my lord.
What opposition?
Affidavit in opposition.
Where?
Kindly allow.
Where you file
Two
affidavit
days,
of
my
opposition
lord.
of
2
this
days.
revisional application?
My
You
lord,
will file affidavit of opposition of this revisional application?
my lord.
Huh? Show me the provision under this, under the criminal revision, there is a provision for filing affidavit in opposition. Show me.
My lord, 2 days accommodation, only 2 days.
For what?
For instruction for my
Okay,
client.
pay the 20,000 immediately first. I am granting 2 days. 20,000, 2 days. If you want the next circuit, per day 10,000 is
No, my lord,
calculate
only 2 days accommodation.
20,000. 20,000. Lost your child, still you are adamant.
My lord,
Still you are adamant and you are the
my
teacher.
instruction, they already paid.
What paid?
They paid the medical. My lord, only 2 days accommodation.
So and so appearing for the petitioner, so and so appearing for the state you are appearing, state is a party, yeah. So and so appearing for the state and so and so appearing for the opposite party. Full stop. The petitioner has filed the present application. The petitioner has filed the present application under section 227 of the Constitution, under section 227 of the Constitution of India. Yeah. What is going on? And all the things have been affirmed also. Filed an application under Article 227 of the Constitution of India challenging the order passed by the Learned Session Judge Kuch Bihar in criminal revision number 42 of 2024 within bracket Ganesh Chand Banik versus Rinki Banik Day and another dated 27th of September 2024. You give the Domestic Violence Act? You are having the Domestic Violence Act?
My lord goes to one document and page 67. 6 lakhs per month, my lord, since 2014. This was the.
You are not having the book. You came before the court for arguing the matter in the DB Act and you are not having the DB Act. क्या बोलना?
The petitioner has filed the present application. The Constitution of India challenging the order passed by the Learned Session Judge Kuch Bihar in criminal division number
42 of 2024 within bracket Ganesh Banik was a Rinki Banik Day and another wherein the Learned Session Judge has stayed has directed show the appeal provision. क्या बोलो? Directed the
29.
20. No. With regard to the appeal.
22.
क्या बोलना?
While the Learned Session Judge has
Directed the opposite party herein, wherein the Learned Session Judge had क्या बोला? Wherein the Learned Session Judge has directed the opposite party number 1 or 2, opposite party number 2 to pay rupees 11,000 being 11,000 within bracket rupees 8,000 to the petitioner wife and 3,000 to the minor son out of the total amount of awarded amount of rupees 15,000 in total rupees 11,000 per month. So he was paying the amount, this amount. So what is, in the event the aforesaid condition is complied with, the stay order is indicated above will continue. In default, the stay order is stand vacated.
He is not paid a single.
So automatically vacated. So why?
My lord, the passing of this order, my lord, we approached this bench and they were stayed. So the proceeding over there is stayed now.
What is it?
The entire proceeding under this.
I am telling with regard to the stay order which the London session judge has passed, that by default already vacated. So what remains? You persons are not reading.
My lord, when this order was passed, after the passing of this order, my lord, we have approached this bench. Because we are aggrieved by this order. There was the direction to pay 5,000 towards the medical expense of the child. Now the trial judge has reduced it to 3,000. So after that, we have challenged it before this honorable court. On the first date, my lord, it was stayed. It was stayed.
Which is what is stayed?
This order was stayed, my lord.
Which order?
This criminal revision number 42 of 2024 has been stayed by the.
Where is the order?
That is the first order of this court, honorable court.
Which dated? Which is the, what is the date? You're not ready, you're wasting time. Son suffering for the petition, son suffering for the states, and son suffering for the opposite party number 2. It is found that the petition is not ready to argue the matter. Case adjourned, let the matter appear on 16th. How many years you are having the practice, sir?
17.
Huh?
17.
And this you have learned for 17 years. Not able to give any answer to the question put by this court. All the matter.
Junior, and she is not anymore in my firm, my lord.
I for the opposite party. I am appealing for the state, my lord.
Neither you have kept the book, nor you have kept the order. I started arguing before the High Court. That's why the matter is listed. You sleeping in the house, and I will take time tomorrow.
It is filed in the name of my earlier junior, my lord.
But the advocate who is appearing in front of the court, he should appear before this court with preparation. Otherwise, not to appear, having a 17 years of the practice.
If I don't know.
If you are not ready, why you appeared before this court? Wasted the court 15 minutes. Yes.
I am appealing. I have come before your lordship for quashing of the proceeding under section 448, 325, 279, 34 of the Indian.
379. Where is the Caesar memo? Where is the Caesar memo? What is required from you? 379.
Allegation of money, allegation of snatching money.
Snatching money. So recovery is there.
No, there is no recovery, no seizure.
So how 379 will prove?
Not, only
If there is no Caesar, how the 379 will prove, sir?
only 161 statement. Only 161 statement.
Apart from the victim suffered serious injury, lordship, may I submit on the immediate lordship? On 2nd of November 20, on 1st of November 2024, this alleged incident took place.
When?
2nd of November.
2nd November 2010.
2010.
So still the case is pending.
Yes.
My lord.
Now, what has happened on 1st of November, this incident took place. On 2nd of November, he was admitted in the hospital, and on the same day, he was discharged.
Who?
The victim.
Correct.
And on 4th of November, this FIR was lodged, stating that he is still in the hospital in the ICU. This is a false FIR, lordship, and nothing has been said. One more thing, lordship, the charge sheet was prepared in the year 2014, and it was submitted in the year 2024, lordship, after 10 years. So
When the cognizance was taken by the magistrate?
2024, lordship.
Have you any order?
Where is the cognizance order?
Yes.
Show me the cognizance order. Show me which.
29th of May 2024.
Which page?
Certified copy.
Order dated
29th May 2024.
29th May 2020. Received charge sheet 14 under section 325, 379 and 34 of the IPC
Yes, madam, 29th of.
with the CD and others. Accused namely so and so, so and so. Please. Where is the cognizance? Cognizance taken. Yes.
So one partner is still absconding according to the document.
No.
Kindly come to the 473 CRPC. No, 469. I have forgot all the CRPC. 469. What is the time for taking cognizance? The 25, what is the punishment? 25?
325.
What is the punishment? 3 years.
3 years.
3 years.
3 years. 379.
379, 3 years.
325.
325, what is the punishment?
7 years. 7 years. 7 years.
7 years. Where the known offense is committed the first day and identify the known person and officer police are making investigation. Completing the period from the such period shall be excluded. Yes. Where the commission offense not known to the person language by the officer of first day.
320. 325. 325. 325. 7 years.
7 years.
7 years.
Available 7 years.
7 years. What is the limitation of the cognizance? .468.
Yes, ma'am.
6 months if the punishable is fine. 1 year if the punishment is not exceeding 1 year. 3 years from the punishment is 1 year and exceeding 3 years. For the purpose of section limitation in relation to the offense of determining the punishment more than 7 years as the case may be. Then what will happen? So 2010, 2014 cognizance.
10 years. After 10 years.
An incomplete charge sheet has been annexed for the petition. Under the petition was the.
Incomplete charge sheet, you are.
The copy.
Huh.
They have already.
468.
The injury report all the collection and nature of. C26 may not be, I will not think that C7 is.
But as per the medical document, my lord, he admitted on 2nd of November 2010 and my lord discharged on same day. This is the medical document. This is the statement of the victim. This is the 161 statement of the victim, my lord.
Yes, then
only allegation of 15,000 snatching from the box of the shop. This is the allegation, but there is no recovery.
Okay. So what is the stage now? That
the stage is the 25th of this month is fixed for appearance and ER of WA.
What is the ground for quashing?
1% is still absconding.
What is the ground for quashing?
Ground is that the charge sheet is submitted 325, 379, but 325 and 379 both section no ingredients there because injury is there is simple in nature and the.
Show me the injury report.
But I have hand over the injury report.
Where is the case diary? This I cannot.
No, case diary. I have also hand over the case diary, madam. Which side? This is the 161 statement, madam, in the case diary.
Where is the case? Where is the injury report here?
But injury report.
This one?
Yes, madam.
You are not annexed in the CD?
No, my lord. Today morning, they hand over the copy, Xerox copy of the same. Last August, last August, the matter was appeared before Lordship, subsequently in that city, the injury report was not there. The earlier, Ujjwal Luksam last August appeared, he requested the honorable judge to produce in the injury report, and that's why the reason, that may be the reason to bring the report.
Yeah, where is the injury? This, how you can rely upon if it is not in the CD?
Not given by the IO, madam, today morning.
Okay, I'm suspending the IO. I'm passing an order. Who is the SP? With jurisdictional PS.
This is Kumargram police station, Alipurduar SP.
So?
SP Alipurduar.
What you are telling, sir? Have you gone through the CD?
Yes, madam, I have seen.
Seen? No report. No report.
No report.
Give. You all persons
madam. Actually, madam.
wearing the
No, madam.
black coat and coming to the court, I am advocate.
No, madam.
Appearing before the High Court.
Actually, my lord, sorry, my lord. Actually, my lord, this case is allotted to Mr. Ujjwal Luksam.
All the things. The
Ujjwal
last
Luksam.
person is only morning high have been. Now high have pointed out, morning high have been allotted. What is going on in the Jalpaiguri? And you have been engaged by the government
Not actually, my lord. This case
as a
was-
PP, additional PP for the state. Without going through the document you are submitting before this court.
আমাকে ডকুমেন্টটা দিলো জেরক্স ইনজুরি রিপোর্ট ছিল ইনজুরি রিপোর্ট ছিল দেখে লোক বসে থাকো উজ্জ্বল সাথে
What is the name of the victim? Nandulal. And second victim? There are two victims. Nandulal. Yes, first he was admitted on 2/11, he had discharged on the same day. Referred to the NBCH, then NBCH 3/11, discharged on 4/11, suffering from physical assault. Scan of the brain. Nandulal sir appointed so, nothing. CT scan and brain, NAD. You are appearing for whom? Defective. What injury you have sustained? Scan is NAD. CT scan, nothing. What is the injury you suffered?
according to my client instruction, he
Not client instruction from record. Client will say I already died.
yes, your lordship. Yes, your lordship, my lord, that kind of he said, my lord, the physical injury, my lord, he was brutally assaulted. Like the learned advocate.
So that's why the record, the court has called for the report. He is telling the number, the report is in the CD. He has been sent as per your request. It was sent to the NBCH and the CT scan was done. Brain CT scan of the brain was done. Nothing was found. Only the history is suffering from physical assault.
Only physical.
No injury. And 379 there is no seizure.
No seizure, but only statement is only the statement of the victim is there. my lord. That the accused person snatched away the 15,000 from my cash.
So if it is snatch away,
Snatch.
when the FIR was, when the incident was occurred,
2nd of November.
2nd November, when the FIR was chalked out,
After 3 days.
3 days.
Fourth.
And when the accused persons have been arrested,
We surrendered before the court.
you surrendered before the court.
Court below and
So-
got bail.
So court bail has been granted.
Yes.
You have not, you might have been interrogated the accused persons.
Yes.
Where is the seizure?
One accused is acronym.
No, both of them.
That is separate issue.
Where is the?
No seizure.
So 317 gone, 379 gone.
79.
With regard to injury maximum, you can go by this 323,
323.
323, 325 does not.
Does not exist.
Then. And 2010 case, now we are on 25.
Yes.
Charge sheet was prepared in the year 2014. It was placed before the magistrate on 2000 in the year 2024. It may be, my lord, with the GRO office. My lord knows, my lord, the
2014 charge sheet, 24 place.
placed. This is the fact, my lord. My lord, maybe charge sheet submitted in the year 2014.
And one year accused is absconding.
Still have 1 year.
No, the other accused, he has surrendered before the court below. And he.
Surrendered.
Document is not.
Actually absconding
No, subsequently.
or subsequently surrendered. That is not in the case diary, my lord. I have seen in the record, my lord, that next date is fixed for appearance and year of W on 27th of this month.
27 of this month.
Yes.
So, but what? If it is not the 320 is there, 323 is there.
You should kindly consider the delay. It is-
Delay, you argue there, how the in the revision, how the court can?
Here, violation of 368.
468.
The court has pointed out then. 379/34 of the IPC. Including the charge sheet right number 111 of 2014 dated 31st of May 2014. 14 pending before the Learned Court of Chief Judicial Magistrate at Alipurdwar. Police counsel for the petition submit that as per the written complaint, of the de facto complainant dated
4th of November.
4th November 2010, the police has initiated an FIR number 239 of 2010 dated 4/11/2010 under section 379 of the oblique 34 of the IPC against you. What is your name?
Jagdish Shah. The petitioner is Jagdish Shah and his brother Amol Shah. Amol Shah.
Allegation is 2%.
Against the petitioner, against the petitioners herein. Full stop.
There is not one petition, my lord. Only
Against the petitioner,
only Jagadish Shah.
against the petitioner, Jagdish Shah and another, namely
Amol Shah.
Shah is the brother of.
Amal Shah. Full stop. Police counsel for the petition submit that though the case has been initiated in the year 2010, but the police has submitted charge sheet only in the year 2014, and the Learned Court of Chief Judicial, which court? Chief Judicial Magistrate, Learned Court of Chief Judicial Magistrate at Alipurdwar has taken cognizance on 29th of May 2024. Full stop. Counsel for the petition submit that though as submit that as per the charge sheet on completion of the charge sheet, the police has submitted on completion of the police has submitted charge sheet for the alleged offence under section 448, 325, 379 of 34. But as per the record, no seizure list is been prepared or nothing was seized from the petitioner to say that the petitioner has stolen any article as alleged by has snatched. Petitioner has snatched the money, has snatched the alleged amount from the possession of the de facto complainant, or any alleged amount was seized from the possession of the petitioner. Full stop. Counsel for the petition submitted that the police has filed the charge sheet under section 325 of the CRPC, but the medical document as relied by the prosecution does not say anything with regard to any previous offence which come under the purview of 329 of 325 of the CRPC. Counsel for the petition submitted as per the submitted as no case under section 379 and 325 was made out, and as such, if it is taken into consideration that the accused has committed an alleged offence under section 323 of the CRPC, but if we go by the charge sheet filed by the police and the cognizance taken by the court, it reveals that it was the case is attracted under section 468. 468. Within bracket 2 within bracket 3 of the Code of Criminal Procedure. As the learned magistrate has taken the cognizance after the period of 3 years from the date of alleged offense. Counsel for the petition submitted that this is a fit case wherein the proceeding against the petitioner can be quashed. Per contra, learned advocate appearing for the state submits that the police has investigated the matter, and after the investigation, sufficient material has been found for the alleged offense under section 325, 379, and 448 of the Code of Indian Penal Code. And if the petition is any grievance, he can face and he can take the defense during the trial. Police counsel for the state submits that investigation has been submitted. Investigation is completed. Charge sheet has been filed. Learned magistrate has already taken the cognizance, and if cognizance, and there is every chance that the case can be and the trial can be over, can be completed. Police counsel for the state submits that there is a prima facie case as per the record available in the CD. A prima facie case has been made out, and as such, the proceeding can be passed against the petitioner. Learned counsel appearing for the de facto complainant submits that the victim has sustained grievous injury and he was admitted in the hospital, and as such, the police has invoked the provisions of section 325 of the IPC. He further submits that the petitioner, along with the co-accused, had snatched the money from the victim, and as such, the police has invoked the section 379 of the IPC, and this is the matter of trial. He submits that if at this stage this court will discharge and will cause the proceeding against the petitioner, the de facto complainant will suffer irreparable loss and injury. Heard the learned counsel for the respective parties produce the materials on record. This court finds that the FIR has been chalked out on 4th of November 2010 for the offence under section 379/34 of the IPC. After the investigation, the police has submitted the charge sheet for the alleged offence under section 448/325/379/34 of the IPC, dated 31st of May 2014. That is mere about 9 years. Mere about the on 31st of May 2014. Full stop. Though the police has submitted the charge sheet in the year 2014, but the charge sheet has reached to the Court of Chief Judicial Magistrate, Alipurduar, only on 29th May 2024. And on 29th May 2024, the London magistrate has taken cognizance for the alleged offence under section 448, 325, 379 of the 34 IPC. This court finds that full stop. The London this court finds that the London magistrate has taken cognizance as per the charge sheet submitted by the police. This court has gone through the CD and found that during the investigation, the police has obtained the medical report of the victim, wherein it is found that initially he was admitted in the hospital. He was admitted in the subdivisional hospital Alipurduar on 2/11/2010, and on the same day he was released from he was discharged from the said hospital and was referred to NBNCH for CT scan. In the said report, it is only alleged that physical assault. There is no report to show that the victim has sustained any injury. Full stop. The police has collected another injury report from the sub-divisional hospital, Alipurdwar, wherein it reveals that the victim was admitted on 3rd of November 2010 and discharged on 4th of October 2010. And the CT scan of the brain was carried out, but after the CT scan, it is found nothing was found in the CT scan. In the said report also, there is no report whether the victim was sustained any injury. Only it is recorded that the physical assault. Only it is recorded that physical assault. The police has submitted the charge sheet for the offence under section 379 of the IPC as per the claim made by the de facto complainant. But this court did not find any document on record that the police has required any amount or any amount from the petitioner or any of the co-accused. There is no seizure list to prove that any amount has been seized from any of the accused to prove that the accused persons have committed an offence under section 379 of the IPC. Full. Considering the above, this court find that considering the case diary produced by the state advocate, this court find that no case under section 379 is made out. As regard the offence under section 325, there is no report with regard to any, there is no report that the victim has sustained any fracture injury. If this court will consider the injury report collected by the police during the investigation, if this court believe that injury report and taken into consideration, it may go for the offence under section 323 of the IPC. Full stop. Section 379 and section 323 and section 448 are the offences which provides the imprisonment of 3 years. Less than 3 years. Section 325 and section 323 provides the imprisonment provides the instrument,
1 year.
provides the imprisonment 1 year. Or fine of rupees 1,000 or with both. Section 379 full stop. Section 379 provides imprisonment for 3 years or with fine or with both. Section 448
Or imprisonment for 1 year.
448 provides the imprisonment for 1 year or fine of rupees 1,000 or both. Taking into concept full stop. Section 468 of the Code of Criminal Procedure. 468 of the Code of Criminal Procedure. Code of Criminal Procedure 468 2 within bracket C within bracket B 1 year if the offence is punishable with 468 it was getting in section 468 of the Code of Criminal Procedure reads as follows. इसको type करूंगा. Reads as follows. Considering the above, if this court believe that the charge can be framed for the offence under section 323, this 323 provides for 1 year. If the imprisonment is 1 year, then the case is covered under section 468 within bracket 2 within bracket B of the said section. Thus, the court, that the cognizance taken by the landlord magistrate is bad in law. Fully. Bad in law. In view of the above, this court find that the proceeding initiated and this court find that though the case has been initiated against the petitioner in the year 2010, but the police has submitted the charge sheet in the year 2011 and 2014, and the court has taken the cognizance in the year 2014. That is beyond the period of limitation as 2024, beyond the period of limitation as provided under section 468 of the CRPC. Accordingly, proceedings initiated against the present petitioner in GR case number 220, present petition in connection with Kumar Gram police station case crime number 239 of 2010 dated 4/11/2010, corresponding to GR case number 2205 2010 under section 448, 325, 379, 34 of the IPC pending before the Learned Court of Chief Judicial Magistrate at Alipurdwar are set aside and quashed.
In respect of the petitioner.
बोला तो है. Set aside and quashed. CRM so CRR number 436 of so is disposed of.
Number 79.
I am appealing for the statement.
Huh? Why? Huh? Pass over. Next. 81. 81.
One have to back for this. I thought it was not husband. I served this notice, but you have refused. This is my agreement. No.
यार take ना.
Yes.
Yes, where is? Written refused. 17 January 2025. Written refused. Yes. Okay. Where is the order? Which order you challenge here?
Office Party Y has been working as the ASA worker in the health sector with the government of West Bengal. By considering since the year 2013, by considering such facts, she has filed the maintenance petition under 25 CRPC and obtained order ex parte. By considering such, nowhere she awards such.
What are the amount awarded?
Awarded amount.
Maintenance amount?
5,000.
5,000. What you are doing?
I'm a laborer.
You are the labor.
I have worked in the tea garden as a labor.
Huh?
In the tea garden, I worked as a labor. But in 2017, this tea garden closed. Thereafter, I used to work as a labor. Many of the times I got no work, and some when I got when I.
Okay. Where is the order?
Kindly come to page number 15, Lord.
15.
15.
15. Yes. Okay, I will go through. Show me the order.
Doctor, I'm coming on the order.
Maintenance order. Okay, where is the maintenance order?
I have a fancy document.
Okay. You carry on as per your wish.
I have a fancy document that they have been working as the ASA worker.
Where is that?
Page 15.
Query number 4C. Srimati Maluti Roy is working as ASA worker.
Since August 2013.
What is the amount they are getting in the ASA worker? What is the payment of the ASA worker?
That you have not asked.
What is the amount of the ASA worker?
Payment after worker is right now, I'm not, I have to take instruction on that regard, but
But Leonard Talcott has not.
Okay,
That's it. One more thing, that's it. Leonard Talcott has not called for affidavit asset from the parties. That's it. My humble prayer is, my lord, that the setting aside of the ex parte order and kindly direction upon the Leonard Talcott to call for affidavit assets from both the parties and express the hearing, express lordship. My lord, only this prayer I need. As because my I am a liberal and see by committing, by making suppression of the material facts, he obtains such advantage in gaining order. That's it. This
You,
That's why she refused to appear before
you
the
got the order of the Kerala High Court, recent order, wherein the Kerala High Court has fixed the guidelines in terms of this Neha.
Rajneesh and Neha, my lord.
Yes,
Kerala I have not seen, but we have gone through the Rajneesh and Neha.
Rajnisha, then now the Kerala, yes.
On when someone suppressing by coming with suppressing or material fact to the court and take order, then what is the objection?
You are appearing for whom? State. Yes, you show me the order. Where is the order of the magistrate? Where is the order of the magistrate? Are you not coming to the main?
And on this aspect, lordship, I have applied for certified copy of the impugn order. And I ran the certified copy application, but the officer department there.
Where is the order?
This is of the record, my lord. Therefore, I have not obtained the certified copy.
So how you file the revision application?
I am challenging the order of the.
Have you taken leave from this court? Without a certified copy, you can file the revision application.
Doctor, I am challenging the execution proceeding, lordship.
Have you taken the leave?
I am challenging the order of the execution proceeding. Because they are claiming in one execution proceeding 51,000, in another execution proceeding they claim 53,000.
Naturally.
And in one, the installment is made 6,600.
What is your prayer, sir?
My prayer is, my lord.
Impugn ex parte order dated 31 December 2014. And you filed the revision application when? 2025. You are having the CRPC?
Yes.
Come to 127. Open 127 and read.
Yes, there is a 3 months, I have to bracket the expiry order. 3 months there is limitation, but that expert order passed without summoning upon me, and I.
So that's why if you have not received the notice only from the date when you have received the execution notice, you came to know the 120, why you have not approached the trial court with 127? 127, there is no requirement of 127. The court, you can file an application for call for the original record 127 with the original miss case.
But for that, I need the original certified copy order.
Sir, I had practice in that side. And 125, how many years you are having the practice? No, how many years total practice? 6 years. 600 cases I have dealt with the maintenance case. And that too free of cost.
My humble prayer is that one that can give me one judgment also that KD Salman judgment also.
Sir, first you satisfied me on the law point. You have challenged the order of December 2000, February 2014. There are 4 lacuna in your case.
Yes, for that,
I could have been passed the order herein now, but you have lacuna. What the judgment says?
Para number 16. Here, observation was made that it is a settled proposition of law that a judgment, decree, or order obtained by playing fraud on the court, tribunal, or authority is a nullity and not as in the eye of law. Such a judgment, decree, or order by the first court or by the final court has to be treated as nullity by every court, superior or inferior. It can be challenged in any court at any time.
Correct.
So, my lord,
but that's why, see, obtain the order ex parte. Correct. You have to prove that they have played the fraud upon the court. A revisional court can say that because if you file an application before the same court, the court will call for the original record. Original record will call whether it's a 125 proceeding. If the 125 proceeding, the court will say the notice might have been issued to you, whether the notice was issued to you or not. That is the thing. Whether have you enclosed the certified copy of the notice? How the revisional court can, if you have to prove the notice was not issued to you, and they have played fraud upon the court, showing this some other document, the notice was served.
I have a privacy document that says me working as a after worker.
That is different thing. That is different thing. That if you go on married, then your case is, your revision is barred by limitation. 2014 or 2015, 11, after the 11 years where the court can entertain the revisional application.
I have come with the knowledge after getting the warrant of doing this execution proceeding.
Correct.
Thereafter, I am paying on every date.
Had to pay, see, today also. I am again telling you, today if the court, today, this court set aside the order. But you have to pay till date.
Yes, I am ready to pay lots, but affidavit accept at least call from both the parties. This order.
So what is the total amount remain?
In one proceeding 53, in next 2 months, I have paid 10,000.
What is the total amount due?
Total amount due is 53 and
2000 when the order was first, 2014, 5,000 per month. So 1 year,
yes.
60 years, 60, and when the execution case was filed. He is also good.
In one case, 51,000 was due, and in one case, 53,000 was due. And out of this, in last preceding months, I have paid. Now it is around 90,000 or something.
90,000 or something.
2024, 6 lakhs is outstanding. 60,000 per year.
Per year 60,000. 10 years is passed, 6 lakhs.
Plus the from the date of filing, the order was from the date of order.
What is the date of the order? That is the order dated 30. Okay, 14, leave aside the 14, 15. 15 to 15, 14, 9 years.
Earlier, they have to file execution case within 1 year. There is also.
So you are having the receipt. You are having the receipt. Money receipt you are having. If you are having the money receipt, you come tomorrow with the money receipt showing that the total amount has been paid. I will set aside and remand back.
If affidavit asset call for not sale, then proof will reveal not sale. That's why they should not be appear before the honorable court not sale. They refuse my notice.
How this court can interfere? Sir, this is the High Court. If I pass an order in your favor, then this order will go all over India. After 11 years, the court has entertained the revisional application. You satisfied? How this court can interfere?
There also ex parte order was passed. Thereafter, because in that case, affidavit asset was not called for, then court asked to criticize the ex parte order and pass.
Affidavit, then again the law point. 2014. 2014. Whether the affidavit asset provisions were there. Then.
Problem not there.
Continuing your
But not say for the
limitation
ends
will-
of justice, not say as because privacy, I can. Privacy, not say they are suppressing the material that.
You do one thing. I am allowing you to withdraw this with the liberty to take appropriate step before the magistrate. If you want that.
That liberty may be. And record the candidate.
Not, I am disposing of. And I am disposing of. I am not touching anything. I am disposing of this application with the liberty to approach before the appropriate court. So and so suffering for the petitioner. Petitioner has filed the affidavit of. You are appearing for the estate.
Yes.
So and so suffering for the estate. Petitioner has filed the affidavit of service showing that the opposite party number 2 refused to accept the notice. Let the affidavit of service be kept with the record. The petitioner has filed the present application under section 528 of the Bharati Nagrik Suraksha Sanhita 2023. Challenging the order passed by passed by the London Magistrate dated 13/11/2024. Passed by London Chief Judicial Magistrate Jalpaiguri in miscase number 37 of 2014. Order passed by the London Chief Judicial Magistrate Jalpaiguri dated 31/12/2014 in miscase number 37 of 2014 and the order dated 13/11/24 passed in mis-execution number 89 of 2019 and order dated 11/12/2014 passed in mis-execution case number 163 of 2023. Full stop. This court find that initially the opposite party number 2 filed an application under section 125 of the CRPC, and the London magistrate had passed an order directing the petitioner to pay an amount of rupees 5,000 per month, being the maintenance. Full stop. Counsel for the petitioner submit that the petitioner was not aware with regard to the case filed by the opposite party. The petitioner came to know about the said case only on receipt of the execution case filed by the opposite party number 2. And accordingly, the petitioner has filed the present application. Counsel for the petitioner submit that the opposite party number 2 has obtained the order of maintenance from the London magistrate by suppressing the fact that she is a ASHA worker and having the monthly income. On the other hand, the petitioner is the daily rated Mazdoor. Initially, he was working in the tea garden, and after after closing of the said tea garden, the petitioner is working as a daily rated Mazdoor and is not having a fixed monthly income. Police. Consider the submission made by the counsel for the petition. This court find that the petitioner has challenged the order passed by the London magistrate dated 31/12/2014, which is hopelessly time-barred. Accordingly, the present CRR number 8 of 2023 is dismissed. 2025 is dismissed. However, dismissal of this application will not prevent the petitioner to take appropriate step before the appropriate court of law for his appropriate court of law for taking will not prevent the petitioner from appropriate step before the appropriate court in accordance with law.
Grateful, madam.
Yes.
82 Malan.
Yes.
I am appealing for the state now. Currently, case date is not available today.
At the counsel for the census.
498 406 Malan. Case date is required.
498A, the maternal aunts and the maternal aunts of the wife and my lord, the one maternal uncle are before your lordship.
498A.
Yes.
498A.
Where is the charge? City is not there.
No.
When?
Tomorrow on the way. I am tomorrow.
16.
16.
Yes. Next.
Lordship, 83 Lordship, I am for the petitioner Lordship.
83 is already there, John. 16, it will come on 16.
Lordship.
Section 84, due to change in brief and no observed certificate is need to receive lordship.
Come tomorrow.
For what application?
1 week, where is the time? Last week, the court will not take all.
I am for the state, my lord, in 84, my lord.
Monday.
Hey, you note.
Next.
85.
Yes.
This is the affidavit of service.
My lord, I am appearing on behalf of the state in this matter.
I'm appearing on behalf of the opposite party number 1, the wife. The
Opposite,
domestic violence petition.
okay.
But initially, so. The petitioner is the husband, he got married with the opposite party number 2. And after 20 years of marital relationship, the lady voluntarily withdrew the companionship.
Where is the order?
I'm saying, just a brief fact, 10 seconds. First, 125 proceedings initiated by the lady, by the wife. An order was passed, page number 55. Directing 6,000 rupees of maintenance to be given, 3,000 for the lady and 3,000 for the daughter. But she files a separate proceedings under the DB Act. But in the DB Act also, considering the previous maintenance of 6,000, the Running Trial Court passes an order of 3,500.
3,500.
3,500 in DB Act.
Page?
That is page 100. So by this time, the 9,500 was the maintenance of all.
Page 100?
Page 100, that is the material portion, Lord.
No, 100 is your affidavit of assets, I think.
Oh, 106, sorry, sir.
106. 107. Respondent is hereby directed to pay interim monetary relief of 1,500 per month to the aggrieved person and ₹2,000 for the minor child.
Yes.
So earlier is the
6,000?
6 and this is the 3,500.
Yes, 9,500.
Correct.
But this order was assailed by the wife
Hmm.
before the district judge.
Correct.
But district judge, after hearing, passes an order, page 134, thereby enhancing the amount of 3,500 to rupees 20,000.
26. All total.
So, earlier 6,125 proceedings and now 20,000, total 26,000. Now, my income, I have placed everything on record. My income, my monthly salary is 52,240. The amount of 9,500 was good to me, I was happy paying that much of amount. But I had, because the son is staying with me, the daughter is staying with the wife.
2 children.
2 children. But I am paying 14,200 rupees every month as my tuition school fees for my son. But I have personal loan.
What your wife doing?
But she has personal, she is a personal tutor, private tutor, and she has, though she has denied that, but she has income from that source also. So 9,500 is something which is convenient for me. I am a government servant, but my salary is on record. 59,000 something is my gross salary, and in hand salary is 52,200.
With regard to the domestic violence, the maintenance was granted on what ground? What is the prayer in the Domestic Violence Act? Monetary relief?
Yes. Yes, monetary relief.
And 125 is also monetary relief.
Monetary relief.
And 120 DB Act, they are not prayed for any residential.
Yes, residential rights also they have prayed for.
So this amount was given for the residential rent or the monetary rent?
No, residential rent rights is in addition to the compensatory amount given.
Residential right was given?
Yes.
In that domestic violence?
Yes.
Where it is?
The next paragraph, page 134, the material part. The respondents are also restrained from dispossessing or in any other manner disturbing the possession of the aggrieved person wife from the shared household at RNC Road, Rajpur, Nivedita Bhavan, Sonapur.
So that means she is having the free residence.
Yes.
Free residence.
Yes. So, this is the case in nutshell. My income, after paying everything.
What your son doing?
He is studying in school.
Which class?
That I have taken instruction.
And what your daughter is doing?
Daughter is also studying,
Which class? Daughter is younger or son is younger?
Daughter is elder.
Elder. Daughter is elder. What, which class you don't know? What is the age?
Daughter is 12, my lord. She is studying in class 12.
And your son is?
That I have.
9 or 10. Okay.
So, my lord, after paying everything, my lord, I have only 17,000 rupees at hand.
Hmm.
My lord, if I pay 9,500 rupees. And my lord, out of that, my lord, if my personal expenses are considered, my lord, that is the minimum amount, my lord, is required for my sustenance as well as my sustenance of my son.
What you are doing?
My lord, I am a junior engineer in the PWD department. So, my lord, this is the case in nutshell. My lord, I am praying that the order passed by the landed magistrate is, my lord, good and does not require any interference. But the interference by the landed district judge, my lord, is not tenable as per the facts of the case.
Where is the finding with regard to the amount given by in the domestic violence? What is the finding? Page number 19 of the input.
Domestic violence first foot.
Huh?
First foot.
No, district judge.
District.
19. 35.
But 133.
Coming to the cause in hand, affidavit of assault liability, respondent husband has stated the civil engineer working as sub assistant has shown the net monthly 52,000.
But the lady, she is having extramarital affair with the person, but I have stated everything in my application as well as before the landed trial court.
Maintenance is, there is no relation with the extramarital affair. That is, in a revisional application. I don't think.
So as per the salary slip, you are getting rupees 85,680.
That is the latest salary slip
Correct.
they have asked for.
Correct.
But in that is the gross salary.
85,680.
Salary and this is the
And after deduction 60,040. No, 400. 60,400 having deducted GPF to 25,000, you are deducting the GPF.
But when it was filed, that time it was in hand salary 52,240.
No, in this case, the
Lordship.
court,
That is the latest
the
salary
finding, the court has to go by the finding. What is the illegality in the finding? So you have taken the plea that you are having the net income of 52,000, but your wife has claimed 90,000. Subsequently, as per the salary, then you are having the 85,600. But you are getting the amount in hand 60,400. Because you are deducting the 25,000 GPF as GPF. GPF is your deduction, not your expenditure. It is a future liability, future saving. Correct. So, and if you are getting the 60,000 and the court has passed an order, here the 20,000 and 26,000. 26,000. Then
6,000 is including with regard to the 125.
correct. That's why including the total 26,000. What is the wrong?
Lord, has no information. My assets and my affidavit of
And your
assets
wife
are
is not working, and daughter is studying.
But she claims that. She claims that. Now, my lord, in my affidavit of assets and liabilities, my lord, I have spent down, my lord, everything. What are my liabilities? So, my lord, my liabilities has also to be looked into by the court, my lord.
Correct. If you're live, that's why if you go by your 60,000, if your 60,000 go by 26,000, it will be minus, then you are getting the 34,000.
But even if 60,000 is considered, my lord, my son's expenditure is 14,200.
What I wanted.
Huh?
My son's
Please.
expenditure is 14,200, my lord, the school fees.
Okay.
My lord, 10,000 rupees I am paying as personal loan.
So if you're telling that your son is the younger, daughter is the elder, daughter is studying in class 12. If you're taking the education and expenditure of 14,000,
My daughter is.
just a minute, if you're taking an 14,000 of the son expenditure, so your daughter is more than expenditure of the son.
Kindly will not allow me to take instructions to that effect also, whether she is studying in class 12 or not, because.
Not even leave aside the not studying in class 12. If you are admitting that for the expenditure of your son 14,200, leave the equal of 14,200, your daughter is entitled to 14,200.
Lord has to see, because my son is studying in Calcutta.
If your daughter is taken
My
in,
son is studying in Calcutta.
And
the daughter is staying with her mother in Alipur. She is also in Calcutta.
So why you are discriminating?
No, I am not discriminating.
Then
Lord, the cost of living in Calcutta and in other parts of West Bengal, Lord, is different.
so your wife is not able to send your daughter to the Calcutta for the best school. You're the you are the assistant engineer.
But I have no difficulty. Let her send the daughter to me. I will
So
take care of her.
why you are restraining why you are
I am not restraining, Lord. The thing, Lord, that my income has to be looked into, because I have to pay at the end of the day.
okay?
And if I do not
Then
earn-
14,200 for
Yes.
your son. Then
But personal loan EMI, I am paying 10,000 rupees.
for EMI of the car.
No, personal loan.
For what for you have taken the
that I have
personal loan?
taken, Lord, for some.
What for the personal loan?
For some treatment, Lord, I have disclosed in the affidavit. For some treatment, Lord, I have just loan taken EMI 9,880 per month for personal loan.
For what?
For immovable property. Loan taken and given budget.
Yes, but you have purchased the
I have two
property.
flats.
So you have purchased the property.
2 flats, yes.
Then
So, Lord, 10,000
so
rupees.
what you are doing with the 2 flats? You might be getting the rent.
In one property I am residing, another property has been restrained by this order, which will be used by my wife. She
Okay.
is not residing there,
Okay.
but that is locked and in her possession. Now, my lord, another house loan 11,000 rupees. So, my lord, total expenses if considered, it is almost around 34,000 lord I have to pay only for this part, 2 loan and my son's school fees. So, my lord, what is remaining for me then, my lord? I have to sustain also my child also has to sustain. So, my lord, this aspect has to be looked into, my lord, while granting maintenance to the wife. And my lord, so far as the daughter's education is.
How evidence have what you have calculated? What evidence you have led to that effect?
My lord, my affidavit of asset and liability is on record. Page 90, page 95.
Age
Page 95.
95.
Yes.
Yes. This is your
This is my affidavit.
Shyama Prasad Biswas.
Yes.
This affidavit of assets filed before the London Trial Court,
Yes.
London Magistrate. Where is that?
Lord, I have got instructions. The girl, my daughter, Lord, she is 18 plus, residing in the mother. She is unmarried.
Loan of EMI 9,800. Took the item being lying in the flat number so and so so and so. Personal loan with itna was paid per month. Personal 9,000. And in the order of the magistrate, how he has justified with regard to your amount? He has taken into consideration of your affidavit of asset.
Yes.
Where is that? $15,000 per month, 80%.
But page number 103. Third line, third para from the bottom, it's a single line paragraph. Both the parties had filed their affidavit of assets and liabilities.
10?
103.
Yes. Second paragraph.
Third para from the bottom, single line paragraph.
104, yeah, yes.
Both the parties had filed their affidavit of assets and liabilities. Considering all the facts available in the record at this early stage, the allegations leveled by both the sides needs further deliberation and trial is required for proving all the alleged facts with the help of cogent evidence. At present, the respondent number 1 is not providing any amount of maintaining his wife. So thereafter, we got other however, since the sum of money is already being paid to the petitioner by the OP.
Where?
This is page 105, last two lines. 105, last two lines. However, since the sum of money is already being paid to the petitioner by the OP, in the opinion of this court, the interim relief granted herein need not be very high, as that might become something for
Hardship to the OP.
Thus, under the above stated facts and circumstances, considering the urgency involved, the petition for interim relief is allowed on contest, and thereafter 1,500 and 2,000, 3,500.
3,500 and earlier is plus
6,000.
9,500. But 9,500 to the both, to the daughter and the wife, it is not so
But
less.
the interim stage, let it be.
It's the interim order.
Yes.
Interim.
Yes. No, evidence is going on. This is the interim.
Yes, interim. It is the interim. So how the session judge has passed an order in the final way? How the session judge can enter into this in the revisional application?
Sir, adding interim order.
Interim order.
So against the interim order, appeal can be filed.
Appeal can be filed. How the session judge can go into so high in the interim stage? Once you are getting the in the maintenance. Sorry, I am setting aside this order.
But she will be, her maintenance monetary relief is.
But kindly see the session judge order it. Elaborate order, what he has given the total what we say story of the husband and wife and the poet. He has given the poetry in there. Has he considered with regard to the affidavit of assets and the evidence led the order passed by the London magistrate? Where? Can you show me from the page before page 133, paragraph 29 of the order?
Please consider the affidavit of assets, madam.
So where is the finding?
Finding regard to the. My lord, he has relied on several judgments because these points with regard to whether the maintenance will be.
I will give 100 judgment on his favor.
That even the unmarried daughter is liable to get maintenance.
Correct.
Yes. Relied on those.
Madam, I am only asking you at the time of interim order. Court has passed an order. What is the total amount? Passed an order for the 1,500 and 2,000, 3,500. And the court has increased of rupees 20,000. 17,000 has been increased by the session judge. That too at the interim stage.
25% is required to be given. This is a settled principle of law. There are Supreme Court judgment in that regard. I rely on one judgment also, my lord. This is passed by a coordinate bench also, my lord.
Correct. In the interim stage.
Stage also it can
In
be.
the interim, show me the interim stage.
No, this is not the.
Then?
This was with regard to the pending life maintenance, my lord.
Madam.
I have challenged the.
Madam, this has to prove by the interim for the interim protection. London magistrate has given the interim protection in the maintenance also. The maintenance is the final order or interim?
Interim.
Maintenance also interim. Then your DB interim. If today the interim is at 26,000, what will the final? 52,000? Sorry, record an order. So and so suffering for the petitioner. So and so suffering for the opposite party. Full stop. The petitioner has filed the present application I am remanding. The matter is pending before the magistrate. Magistrate not disposed of.
No.
So, so this is the, but you have to pay something, some amount is to be paid.
I am paying 9,500.
No, 9,000 you will not.
So let it be 10,000. Let it be 10,000.
You pay the 15,000?
My lord, that will be too much. Right, for
You pay the
Kindly
15,000
consider.
total 15,000 with regard to this and that, then it will be decided during.
Kindly, my lord.
Sorry, daughter is with the wife. Daughter is with the wife.
Let at least the evidence be adduced, my lord. Thereafter-
Then okay,
No, my lord.
dismissing.
She's studying in school, I think.
Which standard?
Techno India Group School, she studied.
Show me.
I don't know what.
Show me.
State has a responsibility. She's a girl child.
Now, if she is studying, then you have to.
She's studying.
But, they have given me the pay slip. Techno India. দাঁড়া না, আমার কাছে কপি থাকলে তো দেবো না তোকে আমি। জাজমেন্ট দিচ্ছি না তো, তো পে স্লিপটা দিচ্ছি একটা টেকনো ইন্ডিয়া।
No, what course she is doing? What is the course?
That's 12 months.
What is the course? No, this is not the 12.
Class 12 months.
Huh?
Class 12 months. Course in class 12 months.
Public school, Kuch Bihar. Class 12. Which
14,000 if he's paying for
which-
the
which-
child, my lord.
which stream? Science or arts?
Expert instruction, whatever documents they have supplied.
That is the problem. You are appearing for your client without taking instruction. Nowadays, phone and WhatsApp and all these things. And the daughter is 18 years, class 12. She might be in the master in the mobile. And so CBSE result, then she has to get the admission in the college. Who will pay the amount?
Sir, may kindly take this session. I do not know what document she is relying.
I am also not, I don't know. 2024 she has paid. What class, which class, I don't know. Come with the total details. When? Tomorrow.
I'm appealing for the state.
But this was washing of the criminal proceedings being Jalpaiguri police station, FIR number 11 of 2021 under sections 341, 323, 307, 506, and 34 of the Indian.
Where is the injury report? Where is the injury report?
My lord, these are the two injury reports are there, my lord. Two victims are there, my lord, defector complainant and his son. Defector complainant is the father and son is also the victim. Two injury reports are there, consecutive.
Assaulted by a brother-in-law. White goon to save his father.
Simple. What will plan that?
Who is the complainant? Sumit Agarwal?
Defector complainant is the, my lord, the first victim, my lord, first victim.
Sumit?
Sumit.
Sumit is the first victim.
Yes, ma'am.
Complainant
Complainant.
Complainant Shankar Lala, the father.
The father of Sumit, ma'am. Father of Sumit.
Complaining against his own daughter, or his wife, and the son-in-law. When is the FIR?
But accused number one is the daughter of victim and my son,
Just a minute, just a
son-in-law
minute.
and grandson of the victim.
Hematoma. Shankar Agarwal.
Yes.
He is the complainant.
He is the complainant. Tender aberration, small hematoma. These are the two victims.
Yes.
What charge sheet filed?
Charge sheet filed
Under what section?
in the same section. ma'am.
No.
307.
307 gone.
307 is not there. Madam.
What is the
307
section?
is not there.
Under which section the charge sheet is?
323 and 06.
wrongful arrest and hurt.
341.
Three 506/34.
Yes. So what are the ground for discharge? What?
What the FIR states.
Maybe in the FIR what be, but the injury report is there. 323.
After completion of investigation, charge sheet submitted.
The FIR says that his son-in-law, he attacked him with coconut rope, chili flakes.
That court will not go into at this stage, sir. 482. Go and face the trial.
You see, this FIR was only drawn only to entangle me under section 307.
307 is not there.
It's not there, Lordship. But kindly see the charge sheet. The police itself is saying that.
Where is the charge sheet?
Simply, it's a probably cause.
Where is the charge sheet?
Yes, page starting the charge sheet as page number 26. And see, kindly see in the FIR 167, 161 statements, they are saying that I have attacked them with knife, chili powder, sticks, ropes, and you see the scissor, nothing has been seized.
Okay. It is good for your defense during the trial.
Charge sheet submitted under section
Why
323.
you persons are disclosing your all defense in the 482 application? You are a criminal trial advocate. Criminal trial advocate never go for the 227 and 482, sir. They will keep their defense in their pocket every time. They will not disclose unless the witness is on dock. I find here all the petitioners are disclosing their defense in the 482 and 227. These are the ground for the 482.
But he is talking about Caesar, my lord. In the 323 cases, my lord, there is no required.
Same evidence before charge, they're not asking anything.
Nothing.
Decline.
Decline.
Cross decline.
Decline.
This is how it's very
After charge. After charge.
If the public prosecutor is clever, immediately will take note of the same in the CD.
Yes.
The cross-examination gone. Your cross-examination gone when you bring the witness coming to the cross-examination. Yes. Tell me.
You see the charge sheet, what the police have given in the charge sheet. During investigation of the case, I have followed the line of investigation. I have visited the PO and prepared draft sketch map of the PO. I have examined the witnesses and recorded their statements on the 161. I have arrested the FIR and technical person with the petition of Amit Kumar and forwarded it with. I have forwarded injury report of the injured person, namely Shankar Nagara complaint and this one
Mr. PP, and you are the additional PP. See, I find in every charge sheet, I have consulted with the superior officer on fair use. This cannot be.
every.
Not.
Every cases, in the every cases. We have also seen.
I have consulted with the superior officer and I have applied the
Cannot. If a good lawyer will come for the cross-examination.
Because there cannot be any interference. Even the court cannot interfere, can supervise, cannot interfere.
If file the charge sheet supervisor, they will, at the time of forwarding, they can advise that.
It should not be written.
Just become
I find
It
from the
became
last
format-
2 days,
it
I find
became
from the
format
last,
right now.
I find from the last 2 days, the same, all charge sheet it is there.
All the
NDPS cases charge sheet, your honor, my lord will back.
Yes.
The injuries are simple in nature.
That is why 323 is there, my lord.
That is the probably.
Correct. See, whatever the evidence, but injury report is there. Correct. Whether this injury was caused due, you have caused this injury upon them, that is a matter of trial.
Matter of trial.
Correct. That is a matter of trial. This court sitting in the divisional jurisdiction cannot decide. And this court only go for quashing, you know, the Bhajan line and now the several judgments. Rarest of the rare case, if the court find there is no evidence, then only court can go in. Correct.
But on 161 statement of the victim also there, my lord.
in the case.
So and
Case
so,
diary.
so and so appearing for the petitioner, so and so appearing for the state police. The petitioner has filed the present application under section 528 of the Bharatiya Nyaya Suraksha Sanhita 2023, praying for quashing of the proceeding of Jor Banglo Police Station FIR number 11 of 2021 dated 9/2/2021 under section 341, 323, 307, 506 /34 of the IPC corresponding to GR case number 34 of 2021 pending before the Learned Chief Judicial Magistrate, Darjeeling, full stop. Counsel for the petition submit that initially the submitted the police has initiated the above FIR on the false complaint of the de facto complainant. Counsel for the petition submit that no injury was caused to the complainant or to the victim, but the police has initiated the case under section 307 of the IPC. Counsel for the petition submit that police has completed the investigation and filed the charge sheet, and from the charge sheet it reveals that there are several contradictions which cannot prove the case for the offense under section 320 cannot prove the case under section 341, 323, 504/34 of the IPC. For counter learned counsel for the state submit that though the case was initiated for the offense under section 341, 323, 307, 506/34 of the IPC, but during the investigation it is found that the injury caused to the de facto complainant and the victim are simple in nature. Accordingly, at the time of filing of the charge sheet, the police has deleted the section 307 and has filed the charge sheet under section 323 of the IPC. Police counsel for the petition submitted. There are several during the evidence, the investigating officer has recorded the statement of several witnesses, which proves that the accused persons are involved in the matter, and due to which the victim and the de facto complainant have sustained injury. Police consider the submission consider the submission made by the counsel for the respective parties, peruse the materials on record and the case diary. This could find that as per the injury report, the victim and the de facto complainant has sustained injury, but not the grievous. And accordingly, the police has taken appropriate step for filing the charge sheet under section 323 and not under section 307 of the IPC. As regard the other sections, this could find that several materials have been collected by the police. That is to be decided during trial. This court did not find any merit in the matter to interfere. Merit in the matter. Accordingly, CRR number 437 of 2024 is dismissed.
Sit it up.